I see, right.
Yeah. Okay. If you have joined us, we're going to start court shortly. Please listen for the calendar call when Justice Gish calls the calendar at 2 o'clock. We remind everyone to please keep your microphones muted. Thank you.
Good afternoon, ladies and gentlemen. Welcome. The Appellate Division, First Department is now in session. As a first order of business, I'm going to be calling the calendar. Please state your appearances, and then I will confirm to you the times that have been allotted for your arguments. I would point out today that we have a long and somewhat complicated calendar in view of the multiple parties litigations we have. So please understand that we've had your briefs and the record on appeal for some time, and please use your time for argument wisely. The first case, People versus John Metcalf, submitted. Gray versus Ulukaya.
Richard Feldman, Rosenberg, Feldman, Smith for Appellant Jure.
Good afternoon, Your Honor. It's Brian Asher from Gibson Dunn for the respondent, Mr. Ulukaya.
All right, and the appellant will have 5 and 2 for rebuttal, and there'll be 5 for the respondent. GSCP Roman 6 Edgemark versus ETC Northeast Pipeline.
Good afternoon, Your Honor. Emil Kleinhaus, Wachtell, Lipton, Rosen, and Katz on behalf of the plaintiff's appellants.
Good afternoon. Good.
Go ahead.
Good afternoon, Justice Gish. Michael Kenny from Wigan and Dana for respondent appellant ETC Northeast Pipeline, LLC. May I introduce my colleague David Cole from the Texas Bar and respectfully ask that the court permit him to argue on behalf of our collective client?
We will admit him pro hoc vice. All right, and for the appellant, I've allotted 7 and 2, and for the respondent, 7 minutes. And Allied World versus Merchants Mutual.
Good afternoon, Your Honor. For Appellant Merchants Mutual, Joseph Poe, Farber Broxton Zane.
Good afternoon. For Appellant Aspen Specialty, John DePhillips from Clausen Miller, and I would like to at this time introduce my colleague from our Chicago office, Don Sampin, who we'd like to have argue the motion today, or the appeal today.
Mr. Sampin? Is he there?
He was.
I'm sorry.
I'm pleased to make his acquaintance, and I will allow him to argue.
Thank you.
All right.
Good afternoon, Your Honor. Gil Kugler from Fleissner Potash, LLP. I'm counsel for the respondent, Allied World Assurance Company.
All right. Each of the appellants in this case are given 4 minutes and 2 for rebuttal. And Mr. Kugler, you have 6 minutes.
Thank you.
Thank you, Your Honor.
Shamalova versus Berkowitz.
As for the appellant, John McLaughlin from McCabe, Collins, McGill, Fowler, Vina Nogan, Judith, and Solomon Sabo.
David Schultz from Barry McTernan and Moore, and we represent the Yeshiva Shar Torah. Appellant.
Good afternoon, Your Honor. Amy Bedell, Louis Joes, Avalon and Villas, on behalf of defendant appellant Alyssa Berkowitz.
Good afternoon, Your Honor. Raymond Gonzalez with Wade Clark Mulcahy, representing defendant appellant Dora Lieberman, irrevocable grantor trust.
Good afternoon, Your Honor. Spencer Bell for the respondent, Joseph Shamalova, as executor of the estate of Kava Shamalova.
All right, thank you. All right, appellant Sabo, you have 4 and 1. Appellant the Yeshiva, you have 2. Appellant Berkowitz, 4 and 1. Appellant Lieberman, 2. Mr. Bell, you have 5.
Thank you, Your Honor.
People versus Morales.
Natalie Ray of the Legal Aid Society for Mr. Morales.
Apologize. Good afternoon, Your Honor. Julia Chariot for Respondent People.
All right, Ms. Rea, you have 3 and 1. Ms. Chariot, you have 3. Harriet Tubman versus HT Development, that's submitted. Reyes Mendez versus City of New York.
Good afternoon, Greg Friedman from Appellate Isaacson Pacheco for appellants.
Good afternoon, Anna Gottlieb for respondent, the City of New York.
Good afternoon, Christine Hilken from James F. Butler and Associates for defendant respondent Jose Antigua.
All right, appellant, you have 5 and 2. The city, you have 3, and respondent Antigua, you have 3. Baltic Fourth versus Stern.
Good afternoon. It's Paul O'Connor on behalf of the appellants.
Good afternoon, Your Honor. Michael McGowan from Westerman Sheehy on behalf of the plaintiffs' respondents.
All right, the appellants, you have 7 and 2. Respondents, you have 7. The next 2 appeals will be heard together. Key versus GSS N3 and 26 Realty versus K&G and Don's Express.
Good afternoon, Your Honor. Jeffrey Hursto for the appellant.
Good afternoon, Your Honor. Alexander Taken on behalf of respondents, plaintiffs, Peiki and Yebing Liu in the second of the 2 actions.
Good afternoon, Your Honor. Christopher Bilski and Associates for respondent KG and Don's Express Shipping, Import Inc. and GSS N3 LLC.
Right, you're an appellant in one of these cases.
That's correct, Your Honor.
Okay, all right. So for each of the appellants, I'm giving you 3 and 1. And the respondent to respond to both appeals 4. People versus Maldonado. That's a submit. Goya versus Longwood Housing. And those are consolidated appeals. 1, 2, 3. There are 5 of them. 2 of them are non-enumerated, though. All right, why don't you state your appearances and then I will indicate the allocation of time.
Dana Catanzaro for respondent appellant Longwood Housing Development Fund Company.
Good afternoon, Your Honor. Tim Shapiro from the law firm of Baxter Smith and Shapiro on behalf of defendant respondent appellant Melcara Corp.
Good afternoon, Your Honor. Jerry DeCamp from O'Connor Red Orlando on behalf of appellant respondent AAD Construction Corp.
Clark and Williams. Mr. Herman.
Sorry, Your Honor, I was muted. Good afternoon, Your Honor. Ellie Herman from Wilson Elser for Clark and Wilkins.
Okay.
Good afternoon, Sarah David with Gallo, Vitucci, and Clark for the 4th and 5th third-party defendant, appellant, respondent, cross-contracting.
Brian Isaac for plaintiff respondent Goya.
Frederick Klein from Sullivan and Klein LLP for Triborough Maintenance Corporation respondent.
All right, now just say before I confirm the times that we sent out to you this morning the order in which will allow you to argue. We understand this is a complicated set of appeals and cross appeals and separate appeals, and that it's not a perfect ordering of argument. But it is a lot of time that we've allotted from argument. And I'll reiterate what I said up front, which is that we have had your briefs and the records on appeal. So we are familiar with the case. And as I'm fond of telling attorneys, he who speaks last doesn't necessarily win. So the order of speaking won't be outcome determinative. Okay? All right. With that being said, all right. Longwood, you get 6 and 2. Melcara, 4 and 1. AAD, 4 and 1. Clark and Wilkins, 4 minutes. Cross contracting, 4 minutes. Respondent, plaintiff, 6 minutes. And Triborough, 12 minutes.
Your Honor, we can reduce our time considering the other party's time as well.
And you, I'm sorry, I don't recognize you. All the faces aren't coming up. Tell me who you are.
Frederick Klein for Triborough.
Oh, for Triborough. So what, I'm happy to reduce your time. What would you like?
How about 7 minutes considering?
7 minutes. Thank you very much, Mr. Klein. Okay, the final case on the calendar is Harris versus City of New York, and that is a submit. That concludes the call of the calendar. The first case for oral argument is Garay versus Ulukaya.
May I proceed, Your Honor?
You may.
Thank you. This is Richard Feldman for Appellant Garay. So this appeal brings up an issue that comes up fairly frequently to Your Honors, which is, do the documents utterly refute the claims in a complaint where a motion to dismiss is granted based upon documentary evidence? And in this case, we contend they not only do not utterly refute, they actually support the contentions of Appellant Garay. The contract that's sued upon is a settlement agreement, which resolved in a case brought by Garay against Ulukaya in 2012, in which Garay, who was an angel investor, had sued to obtain her 53% interest in Shabani.
Counsel, this is Judge Singh.
Yes.
Does NUCO hold defendants' equity interest under the settlement agreement in U.S. holdings?
Shabani's equity, the Ulukaya's equity interest was held by Holdco, yes.
But with respect to NUCO, where did NUCO was assigned the warrants, right, from the warrant holders? So aren't you missing a link there?
No, Your Honor.
Why is that?
TPG owned a certain percentage of warrants. As part of a March 2018 option agreement, TPG agreed to sell those warrants at any period of time within 3 months. That gave Mr. Ulukaya time to arrange his financing. He arranged his financing by structuring a deal with HOOP, the Canadian Pension Fund. And that was simply his source of financing. So he struck a deal with TPG, and then they structured this deal whereby TPG would sell its interest, not to HOOP, and it never sold its interest to HOOP. And that's pivotal to the respondent's claim that this was a pass-through. TPG's interest did not go to HOOP, and there's not a single document that supports that contention. They sold their warrants to Holdco and Holdco 1 and 2. In the third amended and restated operating agreement, it reflects the fact that Ulukaya owned 100% of the equity of Chobani at that moment in time. That third amended and restated operating agreement listed his two entities as the initial members. They completely wiped away TPG. At that moment in time, he owned 100% of the equity, and then he sold it, he sold 20% of the equity in Chobani in different classes of securities, which had no relationship to the TPG warrants to HOOP, of which he obtained an option to acquire 10% of it back, 50% of what he sold, which he could acquire using Hoops's distributions to fund it.
This is Judge Gish, after the transaction with Hoop, did Holdco 2 hold any part of the equity of Ulakaya's equity after?
No.
So for how long did Holdco 2, under your scenario, hold Ulakaya's equity?
It appears from the record that Holdco 2 owned the equity for 19 minutes. But of course, the settlement agreement, which was an agreement meant to secure the payment of a fixed amount to Jure, did not go into and did not split hairs about how long equity had to be held, what Mr. Ulakaya would do with consideration. For all we cared, he could burn it up. It didn't matter whether he made a profit or not. It didn't matter whether he got richer or poorer. He just had to receive money, in which case Jure would get a certain percentage.
But I don't understand, counsel. If it's a pass-through, right, and no consideration was received, why would your client be entitled to a percentage of that?
Judge, because two things. A, the settlement agreement reflected the fact that even if Ulakaya took out a loan and pledged his Chobani equity for it, which he did because he made periodic payments to Jure based upon that, he made no money. When you get a loan, you don't make a profit. You don't keep it because you have to pay it back. It didn't matter if it stuck to him, if it stuck in his pockets. That loan feature demonstrates that that was not the intent of the parties. He didn't have to keep it. All he had to do was receive it. What he did with it the moment in time after that was up to him, but she got her percentage. That's why the concern at the lower court was that he was going to structure around his obligation to pay her when they sued for peace. When they gave up their fight that she was a 53% owner of Chobani. He sued for peace and agreed to make payments to her. And we wanted to make sure he didn't structure around it.
Yeah,
Now
we understand your argument, Mr. Kleinhaus, and you're out of time. So let's hear from Mr. Feldman. I'm sorry.
That's okay.
And let's hear from Mr. Asher.
Thank you, Your Honor. Brian Asher from Gibson Dunn for the respondent. May it please the court. The only question on this appeal is whether Justice Scarpula correctly dismissed plaintiff's claim that she is entitled under the settlement agreement to 10% of the money that Hoop paid and TPG received for a stake in Chobani on June 27, 2018. As Mr. Feldman just said, and as the documentary evidence that Justice Scarpula found to be quote unquote very clear shows, every single penny of that money went from Hoop to TPG. Mr. Feldman talks about structuring around so Mr. Ulakaya could keep money and not pay Ms. Jure, but as the clear documents show, every single penny went from Hoop to TPG. Mr. Ulakaya did not and could not keep a single penny of that money.
But isn't there more going on here? My understanding is when the warrants were recapitalized, right, into common units and preferred units, only the preferred units were sold. The common units still remained. Doesn't that suggest that more is going on than the simple transaction that you've laid out here?
No, it does not, respectfully, Your Honor, because the documentary evidence, specifically the securities purchase agreement that reflects the Hoop transaction, states that all of TPG's warrants were recapitalized into the preferred units.
Also, am I wrong that they weren't common units?
They were warrants for common units, and they were all recapitalized into preferred units, which were all transferred to TPG. And TPG in the agreement,
So you're saying that nothing was retained, in other words, that it was all sold?
That is correct, Your Honor. Everything was sold, and Mr. Ulakaya's entity had no right to keep the equity for a single moment in time, just like he had no right to keep the money for a single moment in time. He only received Hoop's money with the promise under the contract that he would pay it to TPG, which he did, that he would immediately take TPG's equity, convert all of it into preferred units, and transfer it all to Hoop. And that's exactly what he did. And as Mr. Feldman concedes, it passed through within 19 minutes. And Justice Scarpula found that under the clear language of the settlement agreement, money and equity passing through for 19 minutes when you don't have a right to keep any of it, you don't have a right to control it, those are not proceeds under this agreement. And specifically, the parties in the agreement used very specific and clear words to reflect their mutual intent that Mr. Ulikaya would only pay Ms. Jure a settlement payment when he makes money from selling his Chobani equity. They were very deliberate about setting up that requirement. It's the central purpose
What
of
about, this is Judge Gish, what about your adversary's argument that the loans don't follow, or the financing doesn't follow that structure in the agreement?
That's a great question, Your Honor. And the loans exactly follow that structure in the agreement, and the parties were careful to provide for that. In the agreement, it is considered a sale event when Mr. Ulikaya transfers his equity. A Ulikaya entity, which is defined in the agreement as an entity that owns Mr. Ulikaya's equity. When it transfers equity for value, Mr. Ulikaya's equity, it makes a payment to plaintiff. So in the instances where Mr. Ulikaya has pledged his Chobani equity to receive a loan, he has paid plaintiff 10% of that every single time, and he will continue to do so. He will continue to make payments under the agreement as it goes forward. The design of the deal is that he doesn't do so until he makes money from selling his equity. And the parties, as I said, used very clear language in the agreement to effectuate that. Consideration actually received directly as proceeds. A Ulikaya entity, an entity that owns Mr. Ulikaya's equity, must receive consideration directly as proceeds. The money here passed through for 19 minutes. He had no right to keep it. He only got it on the condition that he send it all to TPG, and he did. Justice Scarpula found the transaction documents were very clear in this regard and demonstrated that without any confusion. The definition of Ulikaya entity, which is another requirement in the settlement agreement, is clear. As I mentioned, it is defined to mean an entity that owns Mr. Ulikaya's equity in Chobani. That is the entity that needs to be selling the equity under the requirements of the settlement agreement. That is the entity that needs to be receiving the proceeds for selling that equity. So it has to be a sale of Mr. Ulikaya's Chobani equity. That did not happen here. Holdco 2 briefly held equity that it bought with Hoop's money on the promise that it would immediately convert it and transfer it to Hoop, which it did. The final requirement in the settlement agreement is that it be directly from a sale event. Sale event is a defined term in the contract, and it's defined to be a sale by a Ulikaya entity. And as for the reasons I just explained, since no Ulikaya entity was involved in this transaction, as none of these entities owned Mr. Ulikaya's equity in Chobani, there was no sale event. Now, Mr. Feldman referred to just now and in his briefs at some length other alleged benefits that plaintiff claims Mr. Ulikaya garnered from this transaction. Those are not at issue on this appeal. They were not part of the claim that was dismissed. In fact, Justice Scarpula granted plaintiff leave to file an amended complaint alleging these other supposed benefits. They have filed that
amendment. I ask you to wrap it up because your time is over.
Sure. Well, I can just say that.
Tight calendar today. Sorry, gentlemen.
Exactly. So, Your Honor, I was just going to say those other alleged benefits are live below. It's now with Justice Ostrager. It's not part of this appeal at all. And I'll rest with that. Thank you.
All right. Rebuttal?
Yes, Your Honor. Very quickly. The agreement, the settlement agreement, is not limited just to cash. It doesn't say cash proceeds. It doesn't say net profits. It doesn't say net proceeds. It says proceeds, which includes other benefits or emoluments. We have alleged that Mr. Ulikaya increased his percentage ownership of Chobani through these transactions. That is an issue that these documents do not refute in any way, shape, or form, because the warrant acquisition agreement from TPG does not state the specific amount or percentage of warrants being sold by it to Ulikaya's entity. It does not state it. It just says we're selling everything. How unusual is that in a transaction that's of this enormity, that they do not specify either in the agreement or a schedule the percentage of warrants being sold or the number of warrants being sold? That's
Counsel, how are you able to come up with a quantification of 675 million then in your complaint?
675 million was the amount paid. However, we contend that Mr. Ulikaya kept a significant, retained a significant amount of the equity obtained from TPG, because we know in public release.
So, counsel, when I asked your adversary about that issue in terms of the common units versus preferred ones, do you dispute what he's saying?
Yes, I do, Your Honor. We absolutely.
But isn't that? But respectfully, isn't that really that goes to whether or not defendant benefited from the transaction? So isn't that really part of the amended complaint as opposed to this appeal?
No, Your Honor, because if it's a true pass-through, what passes through is the equity the same equity. That's the argument. It's not just the money going one way, it's the equity going back. And here there's nothing that reflects what was sold from TPG and what ended up in Hoops. It's not the same. And again, if the consideration is received, part of the proceeds, because it's not limited to cash, are the proceeds, the benefits, the contract rights, which he obtained. If he sold Hoops 20%, and he has an option to buy back half of that, he ends up with 90% of Chobani at the end of the day when he started with substantially less 19 minutes earlier. You can't say that's not a benefit. And if that's consideration, if that's proceeds, not cash proceeds, then she's entitled to her 10%. And these documents do not utterly refute that. The lower court jumped the gun.
Wrap it up, Mr.
Should have denied the motion, allowed discovery to go forward, and then had a full-blown hearing on it so that we wouldn't be put to the test of going through.
Yeah, we understand that's the relief you're asking for. Thank you.
Thank you, Judge.
All right, the next case, GSCP, Roman 6 against ETC.
Good afternoon, Your Honors. Emil Kleinhaus of Wachtell, Lipton, Rosen, and Katz, representing the plaintiffs' appellants, the former equity owners of Edgemark Energy Holdings. Your Honors, our clients brought this lawsuit because beginning in late 2017, at the behest and urging of the defendant Energy Transfer, they invested $150 million in Edgemark, a Pennsylvania oil and gas company. The investments were made in direct reliance on representations that Energy Transfer made regarding the construction and completion of a pipeline that Energy Transfer was building to allow Edgemark to bring its product to market.
Counsel, this is Judge Singh. Can you address, which I think is the primary issue here, is the sole remedy argument?
Yeah, well, Your Honor, so our clients are appealing from the dismissal of the 3 non-contract claims. Energy Transfer is appealing from the denial of dismissal of the sole remedy argument. That's the cross appeal. Justice Cohen correctly declined to dismiss the contract claim, which is the claim that Energy Transfer claims is subject to the sole remedy argument. Your Honor, our position
but let's go on. Looking at Section 3, doesn't it say under Section 3 that the sole remedy is to delay or terminate?
Your Honor, that language says that the sole remedy for the failure of any of the conditions is to delay or terminate. And Justice Cohen correctly held that that language does not apply to our contract claim. And Energy Transfer didn't even argue that it applies to the non-contract claim. And he held, number one, that the language doesn't apply and that their argument doesn't make sense. It doesn't make sense because what they're saying is that the sole and exclusive remedy for a false contractual certification that induces the equity investors to fund, or for not warning of an event reasonably likely to cause delay, is to defer the very funding that was induced. So that's no remedy at all. The funding already happened in that circumstance. And the language, as Justice Cohen correctly held, does not support that conclusion. What the provision says is that withholding funding is the remedy, quote, for the failure of any of the conditions in this Section 3.
I'm sorry, Mr. Kleinhaus. Maybe I read the decision incorrectly, but I actually thought that Justice Cohen, what he said is that the sole remedy provision was ambiguous, and you couldn't tell. You couldn't tell, given 2 reasonable constructions of the sole remedies, which one really applied.
He did, Your Honor. He found that the language, he could not decide it as a matter of law. And then he also pointed out what I just pointed out about nonsensical result.
And that's why he thought it was ambiguous. That having been said, I think that there's a robust amount of law from the Court of Appeals in recent years about sole remedies clauses and how this court should be, or the court should be vigilant in acceding to the parties' contractual provisions.
Your Honor, let me address that law. And I think Justice Cohen, on the sole remedy issue on the contract, applied that law and found that the language was at best for energy transfer ambiguous, because what Section 3 does is it says that the sole remedy for the failure of any of the conditions in this Section 3 is to delay funding. That's not how anyone would say that there's no remedy for a breach of Section 2, where there's a false certification or in violation of the contract, a failure to warn of delay. Now, importantly, and I think Justice Cohen recognized this as well, the parties knew exactly how to draft the kind of clear sole and exclusive remedy provision that the Court of Appeals in cases like Nomura has said would apply. In Section 4B of the commitment agreement, the parties agreed that the sole and exclusive remedy under this letter agreement vis-a-vis the equity investors would be to compel their investment. So the parties to this very agreement showed they knew how to draft a clear sole and exclusive remedy provision. They did it in Section 4B. What the language of Section 3 is most plausibly understood to mean is that it prevents the equity owners from suing to require Energy Transfer to bring about a condition, because under this court's jurisprudence, where there's a condition within the control of a party, there can be an implied obligation to bring about that condition. So, for example, the equity owners cannot sue under this provision to require Energy Transfer to complete the pipeline. They can't sue under this provision to say a notice has to be delivered by a certain date. But the parties did not, let alone unambiguously provide in Section 3 that in a context such as this one, where Energy Transfer provides a false certification that induces the equity owners to fund, which is exactly what happened, or Energy Transfer fails to, in violation of the contract, fails to warn of events reasonably likely to cause delay, which is exactly what happened, and that causes the equity owners to fund. The parties certainly did not agree, let alone unambiguously, that there'd be no contractual remedy under Section 2B in that context.
I just want to move on to another issue, which is what you had talked about to begin with, or what you wanted to talk about, which is the fraud claims. So to the extent that you have the letter of intent, and it does have, and you sue for breach of contract for providing a false certification under that, why do you also have, why isn't a fraud claim duplicative?
Your Honor, it's not duplicative because the law of the Court of Appeals in this department, we believe, is very clear that when you have a statement of present fact, not a statement about future intent to perform, but statement of present fact. Now, one of the representations we rely on here was pre-contractual, but to the extent we're relying on the same representation.
Let's put that aside for a moment. Let's talk about the ones that, for the 100,000 that did come within the contract.
Yeah, Your Honor, I'll quote from this court's decision in the MBAI insurance case. It is simply not the case under New York law that any statement, no matter how false or fraudulent or pivotal, may be absolved of its tortious impact simply by incorporating it verbatim into the language of a contract. There's multiple other decisions from this court, the Go Smile case we cited in our brief, the Wild case, the Second Circuit in Merrill Lynch versus Allegheny goes through this law in great detail. And notably, Justice Cohen ended up agreeing with us on this issue and did not dismiss the fraud claim as duplicative. Justice Cohen dismissed the fraud claim on a single basis, namely lack of particularity. And respectfully, we believe that there's great particularity in the pleading here.
All right, you'll tell us on rebuttal because your time has expired. And let's hear from your adversary. Mr. Kenny and Mr. Cole.
Mr. Cole, I have my microphone turned off. My apologies.
It's okay.
I'm now broadcasting. It's good to talk to people in a warm place as we're having a cold snap here in Dallas.
Yeah, we've heard about that.
It's,
You've made the national news.
It's something else, let me tell you.
Yeah. I hope you're all well. Yeah.
So far, so good. We've got some more coming down later today.
Yeah.
There are two contracts here, of course. There's the body of the set of agreements that we call in the briefing the commitment letters. I think the critical provision, it's not one directly related to the claims here, but it's the one that I think puts this in place with the other contracts in this case. It is section 12. Record 252 happens to be the one I have. There are several of these letter agreements. They are all substantially the same. It's the termination provision. And it says that these letter agreements terminate on the payment in full of the commitment. Why? Because the letter agreements are about one thing, the buying of a controlling interest in Edgemark. Goldman and its affiliates plan to make 3 payments. In turn, they would receive certain equity interests. The other contract, the one that Energy Transfer had with Edgemark, is the contract to build the pipeline system, the gathering system that ultimately had the fire that has given rise to this litigation. But that's why this contract serves a limited purpose for a limited point in time. They want to make sure the payments happen in an orderly way. Edgemark wants to get the money so it can go on about its business, and Energy Transfer's role is
this is Judge Singh. Isn't there some textual support for plaintiff's argument with respect to the sole remedy that it governs the timing of payments? I mean, can't that be inferred from the provision?
I don't think so at all, nor do I think the context of this agreement allows it. The examples given of a breach in paragraph 3 is a failure to deliver a project status notice. The alleged fraud is that we said things that were not true in our project status notices. Those are problems with the project status notice. If that affected the payment issues during the scope of this agreement, you could have a claim about that back and forth. There might have been some injunction practice. But if it affects the pipeline, the operation of the pipeline, the reliability of the pipeline, that's Edgemark's claim. We sold the pipeline to Edgemark. And if we built a bad pipeline...
So you're arguing, I'm sorry, are you arguing standing now or what?
I'm arguing it is a standing argument. It's also an argument about what this contract speaks to and why I think the sole remedy provision makes sense. The only thing you'd be talking about in a contract that only deals with making 3 payments over time are the conditions for making that payment. The construction of the pipeline itself and Edgemark's gripe about that construction, that's another contract entirely. One that Goldman then took over when it took over the company. And then it could complain about fraud or whatever it wanted to, as Edgemark in fact did during its later bankruptcy proceedings. But back on this agreement, the parties wanted very little to do with each other. They wanted to make their 3 payments. We wanted to make our certifications. Edgemark wanted their money. So there's a cap where Goldman's not going to be on the hook for any more money than the amount of 3 payments. There's a limit to us. All we have to do is make 3 statements at a certain period of time. And then there's a commitment by Goldman, of course, to provide the money. Edgemark sort of stands their benefits.
To stop you for 1 minute. So under your view of this, if in fact, and we'll assume without deciding that those representations that were made to get the installments of money were false, there's no remedy for that?
Edgemark has the remedy because we would have induced them into buying a bad pipeline. That's where the pipeline construction issue.
Counselor, where did the money come from? Ultimately, where didn't it come from the Goldman entities?
Yes, Goldman invested money, and in return, it got ownership interest. I'm sorry, Judge.
So why wouldn't they have standing to assert those claims?
They have a claim during the scope of this agreement. They might have some kind of a claim against us about not moving quickly, but they got what they bargained for in this letter agreement. They got the interest. It's theirs.
Counsel, what about fraud? I'm sorry to interrupt you, Counsel. This is Justice Moulton. What about a fraud claim arising from the first initial $50 million investment? They allege that there were statements made by the defendant extraneous to the contract that induced them to invest this money. Would that give rise to a fraud claim with respect to the $50 million investment?
The damages alleged in the pleading, the specific particularity, relate only to the payments specified under this agreement. The remedy under the agreement is what it says about that. And I think the agreement was intended to be the sole and exclusive remedy outside of representations that may have taken place earlier. So I think the contracts excluded earlier events replaced it with these two very specific documents, the one about the payment and these letters, the one about construction that Edgemark had with us
This is Judge
independently.
Gish, just
went
to
forth
be
from there.
clear, the $50,000 was transferred before the agreement was entered into, right? With the merger clause. Could that apply to prior transactions?
If the claim is that they put the money in and held on to it and kept doubling down, didn't do something else because of what we did under this agreement, it's inextricably connected. And we explore that further in the briefing. It's perhaps stronger than an argument about the other payments that they have made. It's not the one they pleaded for in their damages in their petition that the trial judge identified as a failure to plead with particularity. But that's a legitimate point. It's an additional wrinkle, but I think it is only ultimately a continuation factually of the specific back and forth that is set out in the paragraphs 2 and 3 of this.
So in other words, your position is you can't parse the 150 million, 50 million going to fraud, and maybe the 100 million allegedly concerns contract damages.
Right. They made an agreement to buy ownership interest, which they got, and other people with different roles, but different parties made an agreement to make a pipeline. Whatever the pipeline issue is, that's what that is. Whatever the investment issues are, that's what they are, all of which are defined by very sophisticated contracts among these parties.
All right, let's hear from Mr. Kleinhaus for rebuttal, please.
Yeah, Your Honor, a couple of points. I mean, first of all, on the exclusive remedy, Justice Cohen heard this exact argument that these contracts, namely the ones with Edgemark and the ones with the equity owners, should be read together. And he concluded correctly that's a fundamentally factual argument not appropriate for a motion to dismiss. And anyway, it's not a good factual argument because once the funding is gone, the 100 million, and Edgemark has it, how is Edgemark the right party to remedy the funding by the equity owners in response to and reliance on a false certification and a failure to disclose facts? The right plaintiff here is definitely the equity owners. This argument about how different agreements all need to be melded together, Energy Transfer can make that to the fact finder, but it's certainly not sufficient for a motion to dismiss to prevent the equity owners from bringing a claim. One other point I'll make is another alternative basis for Justice Cohen's ruling on the contract, aside from his view of the language and the absurdity or the lack of sense in Energy Transfer's position, is that there's a longstanding principle, including under the Abacus case from the Court of Appeals, that there's a gross negligence exception to the extent that there's an exclusive remedy clause. That was an alternative ground. And last point I'll make, Your Honor, on the 50 million and the 100 million is there's great particularity in our pleading. I think I heard my adversary say there's no particularity as to the damages on the 50 million. Respectfully not correct. Page 174 of the record, paragraph 116 of the complaint, and it's elsewhere too, makes very clear that there was 50 million invested. That's the damages amount prior to entry into any contract. And the complaint lays out in detail exactly where, who, when, and why as to when that as to the representations and the facts surrounding that 50 million. So with respectfully, it's not correct if there's not particularity.
Counsel, if I may, this is Judge Gonzalez. So you do make a distinction between the $50 million investment and the later $100 million investment, which then was the subject of the settlement agreement.
We do, Judge Gonzalez. As to the 100 million, we believe there are valid claims for breach of contract and in the alternative, unjust enrichment, as well as fraud and negligent misrepresentation.
With respect to the fraud, counsel, you're referring to the 2015 permit submissions, the January 2016 engineers report, and then the Beaver County Conservation District.
Yeah, you're on. Judge Gonzalez, yes, we believe that the facts underlying the fraud claim, which relate to both the 50 million and the 100 million, include each of those underlying documents that would have shown Energy Transfer the true facts at the time that it represented that there was no project delay and that the pipeline would be ready for commercial service.
Okay. Thank you. Thank you both. Mr.
Thank you, Your
Cole,
Honors.
stay
Thank you, Mr.
safe
Cole.
and warm.
Thank you, Your Honor. I
Drive
appreciate
Fisher
it. I'll go
City.
warm myself now.
Yeah.
We'll lend you shovels.
Okay, the next case is Allied World Assurance Company. All right, let's start with Appellant Merchants Mutual.
Thank you, Your Honor. May it please the court. Good afternoon. This is not your ordinary run-of-the-mill duty to defend case. This case involves a pleading that manufactured allegations for the purpose of creating a duty to defend on behalf of my client when the facts that were known to the asserted additional insured demonstrated that there was no reasonable possibility that there would be coverage at some point underneath.
Counsel, this is Judge Singh. When should we look? Should we look to the pleadings in this case, as I think the body of our case law suggests, or as you advocate, to look to see what occurred at trial?
Yes, Your Honor, thank you. In this instance, we should look to the pleadings when the pleadings are based upon a meritorious claim. In this instance, there was a third.
So then how do you decide that? If we're looking to the pleadings, how do you decide whether or not there's a meritorious claim?
Well, in this action, there was an initial complaint that had no allegation against my named insured at all. The lower court found that there was not a duty to defend based upon that. They found it based upon the second complaint, which was only based upon a third-party complaint that was filed by a party that knew when it filed that complaint that there was no basis for it. The facts that came to light indicated that there was no reason for M. Carey to believe that Quality Craft's extra omissions approximately caused Hodzick's alleged injuries, and that there was no reasonable possibility that that might happen.
Here's my question. There's an assumption based upon your argument that when the original complaint was filed, the plaintiff would have known that your client even existed. I mean, or that your insured existed. And sometimes the knowledge of additional parties doesn't come till later. So what do you make of that in view of the fact that we do have an amended pleading, an amended complaint that does in fact make allegations against your insured?
Well, Your Honor, in this instance, there was sufficient time for Ms. Hodzick to have learned of the identity of all the contractors who were working at the project. If she had wanted to sue everyone who was involved in the project, she could have learned who was involved. The case was filed more than a year after her accident. The fact of the matter is, the only reason that is evident from the record that she sued my client.
So she could have learned without discovery? I mean, it's hard for me to understand. She walks along and she has an accident, and there has been some prior construction. In fact, your insured's defense is we weren't on the job for however long they weren't, and that they didn't cause any condition that she fell over. But how would she really know about that until she starts the original suit against the property owner, which is what she did? And then as things went on, she learned the identity of other people who were potentially responsible. What's wrong with that? That happens all the time.
Certainly, Your Honor. In this instance, Ms. Hodzick actually worked at the Chase Manhattan Bank where the work had occurred, and certainly could have learned who all the entities were who were working on the premises at the time. It's not as if she was someone not familiar with the premises and just happened to be there that day. She was there the Friday before the work was done, and she was there the Monday after the work was done, which is when she was in fact injured. Now, moving forward, the fact of the matter is that M. Carey's own supervisor testified that he had approved of the work that was done by Quality Craft, that there were no issues with Quality Craft's work, that he never called back Quality Craft to do any repairs to the work. And the fact of the matter is that M. Carey therefore knew when it filed its third-party complaint against Quality Craft that there was no reasonable possibility that there's a possibility that a duty to defend or coverage at the end of the day would be found to exist.
Counsel, are you willing to make a distinction between the duty to defend and indemnification here?
Yes, Your Honor. I believe there is definitely a distinction. It is just in this case, we're not relying upon the facts that were actually developed in the case. It were the facts that were known to M. Carey at the time that it brought the third-party complaint. It's not necessarily the facts that were found at trial that would then determine the duty to defend, the duty to indemnify. In this instance, we're talking about the duty to defend, and generally those are based upon the pleadings, the allegations in the pleadings. But in this instance, the allegations in the pleadings were corrupted by a third-party complaint that had no basis in fact.
Mr. Poe, go ahead, you can continue. Ask your
the rule you're suggesting is going to be very difficult to apply, isn't it? I mean, essentially, it disincentivizes insurance companies from providing coverage defenses, waiting for time when the facts have developed to take certain positions.
Your Honor, I don't believe that's the case with respect to this particular instance, because M. Carey was being defended by its own insurance company. We're talking about an other insurance issue here, not that M. Carey was completely undefended in the Hodzik action. This is not a situation where there was no coverage available, where a litigation insurance policy is to be considered along the lines of the Fitzpatrick or Servodone construction cases. This is a matter where really it's just who at the end of the day ends up paying between the insurance company for M. Carey and the insurance company for Quality Craft or the insurance company for Dimensional Drywall.
Okay, thank you. We'll hear from you on rebuttal. All right, let's hear from Mr. Sampson.
Yes, Your Honor, thank you. May it please the court, I represent Aspen Specialty in this appeal. Recall that this case involved a trip and fall that occurred after work was performed over a weekend back in 2010. And cutting right to the chase with respect to Aspen Specialty, the question is whether there is additional insured coverage for the general contractor on that work under a policy issued by Aspen to one of the subcontractors, in this case, Dimensional Drywall. Now, the relevant language of the Aspen policy indicates that there is additional insured coverage, but only with respect to acts of negligence by the named insured Dimensional Drywall, quote, in the performance of your ongoing operations for the additional insured, unquote.
But counsel, are we not supposed, shouldn't we look at the complaint to see if there's sufficient allegations that there was ongoing work and that was the cause of the plaintiff's injury?
Yes, we should, and I want to do that.
And doesn't the complaint carry that water, though?
It does not. It does not, Your Honor. In fact, it effectively alleges that the work had been put to its intended use and therefore completed. And under the policy, it doesn't define ongoing operations, but it does define a completed operation. And what it says is that when work at the job site has been put to its intended use, then the work is completed.
Counsel, doesn't the complaint also allege that there was negligence in the renovation, supervision, and control of the area where the plaintiff fell?
It alleges a number of things in conclusory terms, Your Honor, and it does not negate the allegations in the complaint that the work had been put to its intended use. And if we look at the complaint itself, and in fact, Judge Singh asked, don't we look at the complaint as well?
I guess what I'm asking you is, do the allegations concerning negligence with respect to renovation, supervision, and control get subsumed within the mantra of continuing operations?
They get subsumed within the underlying plaintiff's own allegations here. And the question, again, is whether the work has been put to its intended use. And despite the conclusory allegations of these ongoing duties, which I suggest are conclusory and legal in nature, there's nothing in the complaint that contradicts Ms. Hodzik's own allegations that the action occurred when, quote, she was lawfully on the premises and traversing the area in the course of her employment. And I'm looking at paragraph 49 of record page 48. I suggest to your honors that she would not have been lawfully on the premise and traversing the area. And the area she is talking about here is the flooring work that Dimensional Drywall and the co-appellant here, Quality Craft, had installed over the weekend. She was traversing that area in the course of her employment when this trip and fall occurred. Now, I suggest to your honors that that alone takes this case out of additional insured coverage, because she is effectively alleging that the work had been put to its intended use, as those terms are used in the policy, and therefore it's deemed completed. We can look at other evidence as well, besides her own allegations. We look, Mr. Poe talked about the testimony from the general contractor itself. And the general contractor talked about the fact that all the work of Dimensional.
This is Judge Gish, but isn't it true, at least in this state, we don't really look beyond the pleadings?
Yeah,
you know, what concerns me about what both appellants' arguments are making is that somehow we have to look beyond the pleadings and have additional factual findings. Is this true? Is this not true? Should they have known? Should they have not known? Is there some kind of conspiracy here or not here? So we have little mini trials on the issue of coverage, when I actually believe that the authority is we look at the pleadings, we don't go beyond there. If it's imported that there might be coverage for the acts, we provide for a defense, and it doesn't necessarily control indemnity.
I'm suggesting to your honors that you can decide this case based upon the pleadings itself, and in particular.
Okay, and we'll look at them. We'll look at them, Mr. Cole. Your time is up. You'll have time in rebuttal. Let's hear from Mr. Kugler.
Good afternoon, Your Honors. I'm Gil Kugler for the respondent, Allied World Assurance Company. I will be brief on this because it appears that the court does understand this long-standing and long in effect law in the state of New York regarding defense obligations. I would point out, or just make the comment that I really am confused and don't understand Aspen's argument regarding when the obligation arises. It appears that the obligation to defend arises based on their argument when the accident happens, but and that would be Ms. Hossick's accident. But what the policy says, and what all of these policies say, is that it's the acts or omissions that have to happen during the ongoing operations. So that one is just confusing to me, that argument.
This is Judge Gish. I want to ask you a different question.
Sure.
So this ultimately went to trial, and it determined that none of the insureds, they didn't have any liability here. So there's no indemnification issue here. But there was an appeal, but not with respect to their liability. So when, in your view, did or does the obligation to defend, assuming that there is one, stop?
When there's a determination as a matter of law that there is no liability obligation.
So didn't that already happen with respect to these insureds?
That didn't happen. This case went on for 5 years, this underlying case. That did not happen until we get to really the discovery had been completed. You know, years of litigation went on.
So, counsel, this is Judge Singh. With respect to Quality Craft, there's no appeal with respect to Quality Craft. So isn't that essentially an admission that there can be no liability? So wouldn't it end at least with respect to Quality Craft? Because the second department certainly is not going to.
The question is, when does it end? And it didn't end until the defense obligation under the additional insured coverage did not end until there was a legal determination made. And since there was no appeal on that particular issue, at that point in time, when the time to appeal expired.
So it's from the time of tender to the time of appeal, when the appeal expires.
That's correct. And just keep in mind, Your Honor, that this went on for years. I just wanted to call the court's attention. There's plenty of case law. There's two new cases since our briefing was submitted from the first department that touch on this, on the separate nature of the defense obligation from indemnification obligation, certainly not coextensive as these appellants suggest. But one of them is First Mercury Insurance against Preferred Contractors Insurance. That one was just a few weeks ago from the First Department, January 21st. It has a site 2021 New York Slip Opinions 00368. And then there's another case, Citizens Insurance against American Insurance Company. That one was also the First Department case, October 8, 2020. The citation is 130, New York Supplement 3rd, 289, both of which touch on the way to tell when a defense obligation arises and when that obligation ends. Otherwise, I do not believe that there's anything that I need to point out other than what's in the papers, unless the court has any further questions.
Any questions, colleagues? Okay, Mr. Powell, rebuttal?
Your Honor, I only point out that just to touch upon an issue that came up initially, that we're only advocating here that we look beyond the pleadings, because in the first instance, the initial complaint filed by Ms. Hodzik did not suggest a reasonable possibility that there might be coverage based upon Quality Craft's actual emissions. They weren't named as a defendant. There weren't any allegations regarding its work. At that time, based upon New York law, it was incumbent upon the insurers to look to see if there were actual known facts that would suggest that there was coverage. And at that time, there weren't any. In fact, they pointed in the opposite direction, that there would not be coverage, which is why the lower court did not find a duty to defend was triggered by the initial complaint, but by the amended complaint. Our position then is that when the Quality Craft was named in the amended complaint, those facts that indicated that there was not a possibility of coverage had not changed. There still was not a possibility ever that there would be coverage, and the only reason that we were named was because of this third-party complaint.
Thank you.
Thank you.
Mr. Sampson, rebuttal?
Very, very briefly, Your Honor, I think the court can look beyond the allegations of the pleadings under specified circumstances. One circumstance is where those facts beyond the underlying complaint do not conflict or do not overlap with the underlying claim itself. This is one such case. And also in circumstances where it's the insured itself who has made certain admissions relevant to coverage, such as the general contractor did here. In any event, whether you look beyond those, the allegations of the complaint or not, the complaint itself alleges, as I pointed out before, that Ms. Hodzik was lawfully on the premises, traversing the area where this work had been done, traversing the very floor that these contractors had installed, thereby indicating in the course of her employment that the work had been put to its intended use. Under those circumstances, as defined in the policy, the work was completed, and therefore there is no additional insured coverage. For those reasons, Your Honor, I would ask Your Honors not only to reverse the summary judgment in favor of Allied, but also to grant summary judgment in favor of Aspen. Thank you.
Thank you. Thank you all. The next case is Shamalova versus Berkowitz.
Yes, Your Honor. John McLaughlin from McCabe Collins, McGill, Fowler, Bean, and Hogan for the defendant appellant Sabo. Please the court. This is a matter involving a slip and fall on snow and ice on a portion of a sidewalk that is not adjacent to the Sabo's property. I think it's without question that the portion of the sidewalk that plaintiff alleges to have slipped on is adjacent to the Berkowitz property. That's because before Ms. Shamalova passed
it's also
away,
adjacent to the easement. That's the issue, right?
Well, It's not adjacent to the easement, Your Honor. Before she died, Ms. Shamalova specifically marked a photograph that was attached to her affidavit. And also at a deposition, her brother, who was present when the accident happened,
I'm
marked the
looking at them.
photograph.
Yeah, both photos, yeah.
And if you compare those to the location of the easement that Ms. Berkowitz, who would be the owner of the property that is the grantor of the easement presently, marked, which is page 705 and 609 of the record, the same photograph. It's a little bit clearer on 705. You can see that the place where both the deceased plaintiff and her brother Joseph Shamalova said that she fell is not in this easement location.
No, but couldn't the various defendants have dumped snow in that area? Because it's fairly close to the curb cut.
Well, I don't know about the other defendants, but not the Sabos. Their affidavits and their testimony are that they, when they did shovel from this easement location, as indicated in the photographs, they would put the snow in the street or on the other side, the yeshiva side of the easement.
Counsel, that information was provided by the wife, but the husband is the one who supposedly did the clearing, and I don't know that he included that information in his affidavit. Would that be correct?
I believe he did, Your Honor. I'll take another look at his affidavit, but I believe that they jointly would shovel snow from the area. I believe he did say in his affidavit where his shoveling efforts would be, but my understanding is from their affidavits and their testimony that when they shoveled, it would be the snow would either go into the street or on the yeshiva side, which if you're looking at the photograph, would be to the right, and the place where plaintiff fell would be to the left, all the way by that no parking sign, which is in front of the Berkowitz property. So, you know, it's the Sabo's position that we didn't have a duty to maintain that area where plaintiff fell. It's not adjacent to their property. It's not in the easement, and they didn't cause and create the condition or exacerbate the snow or ice condition. So I believe the lower court erred in saying that the testimony was too convoluted and opaque. The photographs establish where the easement was, and the testimony and the affidavits establish what the Sabos did in respect to the snow and ice in the easement. And the Sabos established a prima facie entitlement to summary judgment, and plaintiff didn't provide evidence to establish a tribal issue of fact. And instead of granting the motion, the court determined that the evidence was too convoluted and opaque, but I believe the evidence is clear.
Thank you. Thank you. All right. Appellant Yeshiva, Shari Torah.
Yes, good afternoon. My name is David Schultz from Barry, McTiernan, and Moore. We represent the Yeshiva Shar Torah in this action. If I could pick up where Mr. McLaughlin left off, the easement is, I think, what confused the lower court. And as far as the yeshiva is concerned, the accident clearly did not happen adjacent to their property. And it happened as both Ms. Shamalova, her brother, her son, and her friend all put this accident occurring to the west of the easement. And as far as any confusion,
I know it's your claim that it didn't happen on the easement, although it's not really clear to me how big the easement was, but leave that aside. I'm going to assume you're correct. Didn't it happen on the public sidewalk adjacent to the easement?
Well, it happened when you say adjacent to the easement's the driveway easement. And so
yeah, but you have to go over the public, you have to go over the cutout on the public sidewalk to get to the easement, right? True. So if they're parking their cars, there's no way that they could park their cars without going over this portion of the sidewalk. Yes, no? Did I miss that?
They parked, the Shamalovas and Mr. Jones parked their car parallel to Roeder Avenue, and they parked their cars to the west of the driveway easement.
Understood. And how did they get into the driveway?
If they were going to go into the driveway, they would have driven over the sidewalk. That is correct.
Then we're agreed. Okay,
right.
Thank you.
However, Administrative Law 7210 talks about the owners of properties. It does not put the duty on easement owners to remove snow, address conditions next to their.
Do they have a common law duty?
At least with this portion of the sidewalk, the yeshiva does not. The yeshiva is on the other side. There's the.
Council, this is Judge Singh. And just to follow up on that question, isn't there also testimony from the Director of Operations that in fact the yeshiva did shovel the sidewalk for the convenience?
That's taken a bit out of context. What they said was their custom and practice would be to go shovel the sidewalk next door, and as good neighbors, maybe sometimes they would go over. However, the custom and practice doesn't come into play here, as all three witnesses who were alive when they testified said that there was no shoveling had taken place whatsoever. They said it had not looked as if anybody had addressed the snow. So this isn't a case of who should have shoveled, who didn't shovel. Nobody shoveled. And as far as whether the yeshiva or
are there records? Did your client keep records in terms of how they did the shoveling, when they did the shoveling?
They didn't. However, for this particular date, the yeshiva was closed. So the yeshiva's purpose for shoveling was for students that might come to the school. In this case,
but also, I'm sorry, Council. Also, the testimony is for the safety of pedestrians, right?
That would go hand in hand with this, but the reason why the yeshiva would have their maintenance staff go out and shovel next to their property was for the students that were coming in. There is no debate. The school was closed for Hanukkah break. They did not do, setting aside the fact that there's no evidence that anybody shoveled, there clearly wasn't yeshiva. They were
this
closed.
is Judge Gish again. Does it matter in this case that the other defendants in this case testified that yeshiva regularly shoveled that area of the sidewalk?
If there was evidence in the record that somebody shoveled, sure, I would be on board with what you're saying. However, the record is very clear. Nobody shoveled. And then I guess unless the court has any further questions, I'll rest on my brief.
All right. Any questions, colleagues? Okay, we'll hear from Appellant Berkowitz now.
Good afternoon. May it please the court. My name is Amy Bedell from Louis Joes Avalon Aviles on behalf of defendant appellant Alyssa Berkowitz. The crux of Ms. Berkowitz's argument is that because she was the abutting landowner to the adjacent sidewalk, she had no duty she was exempt from a duty under section 7-210 of the New York City Administrative Code.
Is it clear, Counselor, that your client used the premises just for residential purposes? Isn't there some suggestion that there was a commercial aspect to it?
Well, I have a couple of responses to that, Your Honor. We argued in the court below that 7-210 applied because she's a single family owner occupied, etc. The plaintiff failed to oppose that. It was only brought up by the plaintiff on appeal for the first time when some testimony was raised about a garage that Ms. Berkowitz owns, that an individual who repaired a gate for her asked her as a favor, in her words, to store some materials in her garage. In her testimony, she made clear that she did this as a favor, and also that she received no financial.
And wasn't there also a sign put up? Something, as I'm recalling, there was some kind of sign also put up?
Yes, there was a sign put up. It was the same individual. She received no payment for that. It was, based on the cases we have in our brief, it was a purely incidental use and not sufficient to make her fall outside of those exceptions. Okay, so the rest of our argument also is, being that she's statutorily exempt, in order to establish liability, it would have had to have been established that Ms. Berkowitz either one, created the defect or caused the defect to occur through a special use. Now, it was established, and plaintiff doesn't dispute, that she was away from the property for several days before the accident occurred. And plaintiff's witnesses testified that it had only started snowing the night before. And Ms. Berkowitz testified that there was no snow on the ground at all before she left for vacation. So, number one, she did not create the defect, and I think the record demonstrates that fairly clearly. Two, on the issue of special use, that would only occur if she, say, drove over the area where there was, but there is no evidence of, in plaintiff's testimony established this actually, there's no evidence of weight of vehicles having driven over the area where Ms. Kamalova circled on her photograph. There's no tire tracks.
Well, how could there not be cars that drive over that part of the sidewalk? I don't understand. There's a parking lot where people are parking cars. How did they get in there? Did they fly? I mean, seriously.
I believe, Your Honor, if I may, it's established through the photographs that were taken by the plaintiff's witnesses. One at page 294 of the record, it's a color photograph that shows the areas where Joseph and David circled. Right to the, on the top photograph, if you look at it, you can see where the driveway is. There's an absence of snow in the area where that driveway actually is located. And the snow alongside that driveway, in the color photograph at least, you can see that it's brown. If you look over at the circles where that are the circles that were made by the witnesses.
Again, I don't understand. I thought the photographs were taken the day after.
They were taken the day after, but
so you know, snow is one of those things. It's here today, it's gone tomorrow. I don't understand that.
Well, also, if you look at the photograph next to Ms. Shamalova's affidavit, the driveway is shown in that photograph. The only area that cars drive over are where that pole is in the middle of the photograph with the white building in the background, and to the right of that to the brick building. Hers is well to the left. And I think there's no other evidence that shows, other than this one photograph on page 294 that shows the driveway and the absence of snow where the driveway is located, and that only the appearance of only footprints where her accident occurred, according to her own witnesses, and the fact, in addition, that Ms. Berkowitz was not there to drive over that area makes clear that there was no special use.
Okay, thank you. You'll have time on rebuttal.
Thank you.
Let's hear from Appellant Lieberman.
Good afternoon, Your Honors. I believe the prior counsel have already gone over the facts of the case, and many of their arguments are similar to mine. I would only submit, for the record, the plaintiff decedent passed away, unfortunately, before there was any testimony provided. So as far as proving whether or not my client, Dora Lieberman, provided any kind of cleaning aspects to that, we've already put, and my client has already testified, that he did not put any kind of shoveling of snow onto that particular part of the sidewalk where claimant alleges she fell. Again, I will, my prior counsel have already shown you the places on the multiple photographs where plaintiff said she fell. And so my client never ever shoveled snow and put snow on that. And plaintiff counsel, in his brief and his reply, stated that, I believe he stated that my client does not know where he put on any kind of snow on the sidewalk. So right there, you're seeing evidence that there is no affirmative evidence showing that Dora Lieberman, my client, put snow on the sidewalk, causing the accident somehow.
Well, Dora herself didn't testify. Her son testified, right?
Her son testified, yes. Yeah.
Presumably, he'd be the snow shoveler in the family.
That's right, yeah. And he gives firsthand testimony stating that for myself, I never put on any kind of shoveling of snow onto that particular portion of the sidewalk. There's no one else on the record, including co-defendants, who have stated to the contrary.
Okay, thank you.
Thank you.
All right, let's hear from Mr. Bell.
Good afternoon, Your Honors. Your Honors, I'll be brief. You have our papers. The record reflect that Ms. Shamalova passed away prior to her ability to be deposed. However, in her affidavit, she clearly testified that the location where she slipped and fell was the driveway to the parking lot. The defendants all maintained that they used a portion of this driveway as an easement to access this parking lot. And
Was the driveway on the public street, or was that part of Ms. Berkowitz's property?
Well, it was an easement over Mrs. Berkowitz's property, Your Honor, on Roeder Avenue, in between Coney Island Avenue and East 10th Street.
So did she fall on the easement, or did she fall on the public sidewalk?
Well, Your Honor, it's our position that she fell on the easement, and the record is devoid of any evidence of any meets or bounds of the easement. The defendants conveniently indicate that the easement is only to the eastern portion of Roeder Avenue as opposed to the west where Miss Shamalova unfortunately fell down. Her companions who were with her at the time of the accident all testified that the area where she fell was a driveway. Her brother, Mr. Shamalova, Joseph Shamalova, indicated that it's where the curb and sidewalk starts, the slope. Her son, David Shamalova, indicated that it appeared to be the start of a driveway apron. So for the defendants to pick and choose as to where the incident occurred, by operation creates a question of fact, which the lower court appropriately utilized in denying all motion for summary judgment. The lower court used a reasonable inference to indicate that where the accident occurred was a portion of the easement, and the defendants have as move-ins failed to meet their prima facie burden concerning that issue.
Is there any theory of liability in the event that she didn't fall on the easement in terms of the defendants or individual or collective responsibility to maintain that sloped area where she fell?
Well, Your Honor, I believe the evidence, and I will concede that there's no evidence that there's a cause and creation of any defective condition. I would argue, though, that based on the testimony of Ms. Shamalova's companions, that the frozen area appeared to have engraved shoe prints, that the snow appeared to be dirty, would be enough evidence to indicate a constructive notice of the dangerous condition.
But you're not making any argument about cause and create?
No, Your Honor, I would not.
Okay. Colleagues, any further questions? All right. Mr. McLaughlin, you have rebuttal? Mr. McLaughlin, John McLaughlin?
He's muted.
Oh, here we go.
Okay.
I'm sorry, Your Honors. As far as the argument that the defendants didn't establish the boundaries of the easement sufficiently, Berkowitz, who is the owner of the property that would grant the easement, clearly marked a photograph with the boundaries of the easement, and the defendants testified as to
would you trust that? I mean, you know, that's usually a property issue. We do away with deeds and things like that because people know where the boundaries are on their property.
Well, respectfully, that was her testimony, and she marked the photograph.
I'm sure it was her testimony, but is it really probative of the metes and bounds of an easement?
Well,
that's what I'm asking you.
Well, I believe it's sufficient to establish prima facie the metes and bounds of the easement, and it's up to the person opposing that those are the metes and bounds to say, no, it isn't. Here's a survey. This place where she marked is this many feet.
Even if it's the defendants who are the move-ins here.
Yes, there's been testimony and a marked photograph. This is the easement, and there's been nothing offered in opposition to say that that isn't.
Okay. All right, and let's hear from Ms. Bedell. Rebuttal.
Thank you, Your Honor. Just very briefly, I think for Ms. Berkowitz, as I discussed earlier, whether or not the court determines that the defect was on the public sidewalk alone or on the portion of the sidewalk through which the driveway runs, as plaintiff contends. In either case, Ms. Berkowitz established that she neither created the defect or established the defect through special use. So I think in any case, I think the Supreme Court should have granted Ms. Berkowitz's motion, and I respectfully request that the court reverse and grant summary judgment in Ms. Berkowitz's favor.
All right. Thank you all.
Thank you. If I may, this is David Schultz.
No, you know, everybody's gotten the time that they were allotted.
I was just going to point out where the driveway.
You know what? What does no mean? Honestly, we have a very busy calendar. You don't have the time. It's not fair for you to do that, sir. Okay, People versus Morales.
May it please, good afternoon, Your Honors. May it please the court. Natalie Ray of the Legal Aid Society for Mr. Morales. The question in this case is whether the court, erred in assigning points for drug abuse under Factor 11 and in denying our downward departure to a level 1. We believe the answer is yes. There was no clear and convincing evidence of drug abuse. In fact,
so
there
if
was.
You're right about that, counsel, isn't your client still at presumptively level 2?
If the points for yes on that factor, if that alone.
The question then is the discretionary decision for downward departure, right?
Correct.
So why is that proper in this circumstance?
Well, I think that the main argument is that this is a relationship where the non-consensual nature of it was based on age, and the guidelines.
What was the age difference in this case?
Well, I don't know that it was, I don't know, 12 years or so. I don't know that the age difference.
Under my count, it's 16 years. Am I wrong that it was 16 years?
He was 30 and she was 15.
Okay. Well, according to my notes, it was 16 years. But in any event.
Well, in any event, I think it's a good.
You would agree.
Well, it's a good point, Your Honor, because I think that Judge Bruce was disturbed by this also. And I don't think that the morality or that the societal approval of the difference in age is the issue here. The issue here is that there was, whether this was consensual because non-consensual because of age.
So let's go beyond that. So my understanding of the record is that the victim's father says to the defendant what the age is, and your client still continues that relationship.
And that makes it the crime for which he was convicted and for which he served 18 months in prison. The question whether the risk of reoffending because of this non-consensual, age-based non-consensual relationship. In the guidelines, they make it clear that when that's the case, there often is the 25 points under sexual intercourse becomes often an overassessment. And in this case, if you count that, follow the guidelines and say it is an overassessment to the extent that it's 25 points or 20, then you would be down to a level 1.
Yeah, this is Judge Gish, but it's a discretionary downward departure. It's not an automatic. Otherwise, you wouldn't get the 25 points to begin with. So tell me, if the age difference, according to you, the age difference is not something that the court could have looked at to otherwise say, no, this is not the kind of consent that otherwise qualifies for a downward departure, then what would be?
Well, I don't think what would in this, I don't know what would be. I know what's not in this case. In this case, these two individuals met in a chat. They talked on the phone.
It doesn't make it any better. There was 16 years difference between them.
Again, Your Honor, I'm just saying that she talked to him on the phone when her father wasn't there. It is what it is.
I'm sorry. Are you suggesting that somehow she's responsible for it because she talked to him on a phone?
I'm just saying that the consent part of it, I'm not saying, I'm not being responsible or accusing anyone. I'm simply saying that this is not a kind, that it's not no consent because of age.
But you're dealing with-
But that's not
I'm
the
flabbergasted
criteria.
by your argument. I am absolutely flabbergasted by your argument that a 15-year-old can give consent. I don't understand that.
That's not what I'm saying.
Is this truly your strongest argument?
No, Your Honor, I am not saying, as a matter of law, a 15-year-old cannot give consent. What the guidelines say is that when the lack of consent is based on age, then it can be that the 25 points of the under factor 2 may be an overassessment.
But I'm sorry, counsel.
That's the key. Maybe.
Yes.
And
That's
so
correct.
we look at, and here's what I'm going to ask you, because I'm a little confounded by your argument too. You know, certainly if the respondent was 3 years older, 18, and he would have been held responsible for this, then it might be an overassessment, because there's an indication that maybe a 15 and 18-year-old are contemporaries. But how do you equate that with a 30-year-old who has a certain maturity and should have a certain adult level that would bear a greater responsibility, particularly when he knew she was 15? Why don't you think that that's a risk of recidivism?
Okay, first I will say, if my client had been 18, I would have a better argument. I'll concede that.
Sure, bud.
Thank you. But in this case, what I'm just simply saying is it is a crime, right? Regardless of his age, it's a crime. But the conduct was a conduct where the court, and we made it, you could disagree, but I would make one more point, is that it's a question of risk of reoffending and being on the internet for life. He served 18 months in this case.
Yeah,
and
I understand there's consequences to it, but that whatever. We understand your argument.
And it would be consistent. I will just add one point, that it would be consistent with what Massachusetts found, that he should not be on the internet.
Not Massachusetts, though. Maybe they would. All right, I'm going to hear from your adversary.
Thank
Go
you.
ahead. Ms. Chariot?
Your Honors, I think that the facts in this matter speak for themselves. I don't think that I could add much more to what Your Honors have already noted, which is this is not the case in which I think the guidelines envisioned, where the points were an overassessment. I think that Judge Bruce was correct in his discretion and denying the downward departure, and I'll rest on my papers.
Any questions?
If there's no further
counselors?
questions, yes.
All right, Ms. Rhea, we'll give you another shot. You have rebuttal.
Thank you. I think I'll spare you. Thank you.
Thank you. Thank you both. Reyes-Mendez versus the City of New York.
Good afternoon, Your Honors. Can you hear me and see me?
Yes, sir, both.
Okay. Thank you, Greg Friedman for appellant. You've probably seen the papers on this case are pretty extensive, so I'm going to try to reel things in just for the sake of oral argument. I think essentially what we have is just a question of burdens. As a preliminary matter, unless you want to do otherwise, I don't want to focus on the 9180 claim. We do know that plaintiff missed 3 days of work. I think the issues here go more towards significant limitation and permanent consequential.
Isn't the issue here, counsel, whether or not there were degenerative changes that your client exhibited prior to the accident, based on his own MRIs?
I would say no, and here we have a case where it does not appear that even defendant's doctors reviewed the films. It appears they may have reviewed reports that had positive findings, and then in their IME reports, at least Dr. Berman, who is the orthopedist, essentially said, well, my findings don't match what I see in the MRIs, or everything is degenerative. And I don't think that the expert neurologist made the same conclusion, or that defendants even pressed the causation argument in the underlying papers. What they pressed was essentially Dr. Berman's opinion that yes, plaintiff had injuries. They thought they were sprains that resolved. I think that's the heart of the issue here. And
don't we, this is Judge Gonzalez, don't we have another problem because the plaintiff's PMR doctor examined the plaintiff 4 years, almost 4 years after the accident in 2013, meaning that we don't have any contemporaneous medical findings with respect to the plaintiff?
well, as to our expert's examination of the plaintiff, I believe was approximately 3.5 to 4 years after the accident. That's true. I don't think, and defendants correct me if I'm wrong, that they specifically raised a gap in treatment argument in the papers below. Plaintiff himself testified that after...
I don't know that I'm talking about gap in treatment, but go ahead.
Well, I'm trying to relate that to the contemporaneous. As far as contemporaneous goes, it goes essentially to the issue of causation, which, from looking at the record, defendants don't legitimately dispute. Plaintiff, per their own records that they submitted in opposition, went to the emergency room where, granted, I saw there was complaint of knee pain, which doesn't appear to be an issue here. He also complained, however, about lower back treatment, and then within a week or so of the accident, began receiving therapy for his back, his neck, his shoulder. And even though defendants submitted what looked like selective excerpts from plaintiff's physical therapy records, and they're largely handwritten, they do indicate that plaintiff essentially had not only complaints of pain in those body parts, but stiffness or restrictions as well. And those were all within a few weeks at most of the accident.
Counsel, this is Judge Singh. Did your doctor, and I'm Dr. Tataski, I think?
I think it's...
Sakis.
Never mind. I was going to try to correct it for you. I gave up before I started.
Okay, but does he address the MRI report findings?
He does, actually, in his report. If I could find the exact page for you, I will direct it to you. I believe it's approximately 492 of the record, where he basically addresses the fact that there were positive findings in those reports.
So he's acknowledged.
And at the same time, obviously, tested plaintiff's range of motion, found that there were very significant limitations in pretty much every plane.
But doesn't that beg the question as to what the cause is? I mean, whether it was degenerative or the accident?
Like I said, I believe that it was only one of defendant's doctors, Dr. Berman, that even gave a terse indication in his IME report that plaintiff's conditions were degenerative. And I did not see anything in there, whether based on the reports or other evidence, certainly not the film since they weren't reviewed, actually supporting any claims that plaintiff's injuries were solely degenerative, especially because I believe that plaintiff was in his mid-20s at the time of this accident.
Okay, we'll hear from you on rebuttal. Let's hear from your adversaries. All right, City of New York, Ms. Gottlieb.
Good afternoon, Anna Gottlieb for Respondent City. May it please the court, I'll be brief here. This court should affirm. The record here indicates that appellant did not suffer a serious injury. The facts here tell us everything we need to know. Right after the accident, plaintiff very briefly presented to the ER where he was only treated with over-the-counter medication. He did not complain about his shoulder. He very briefly complained about his lower back. He received an x-ray for his right knee, which was his primary complaint at that time. He only missed 3 days of work. He then began physical therapy at the recommendation of his friend, the driver in this case, not upon any kind of medical recommendation. And those contemporaneous medical records indicate that he exhibited a full range of motion shortly after the accident. This is then confirmed by the two doctors who examined him, Dr. Berman and Dr. Carciente. The orthopedist, Dr. Berman, did a full examination of various ranges of motion using the standard AMA guidelines, finding that everything was normal. And Dr. Carciente, a neurologist, also found that there were no neurological findings here. So after these two examinations, it seemed that there's nothing.
Yeah, but counselor, Dr. Tasatsky, he found that there was restricted range of motion. So why isn't there an issue of fact based on what your doctors find and what his doctor found?
So there are a few issues with plaintiff's expert opinion here, who was retained after the summary judgment papers have been filed, and his findings are incredible in that in 34 different areas he finds abnormal ranges of motion. But even setting that aside, he doesn't address the fact that that plaintiff exhibited normal ranges of motion earlier, and case law from this court shows that in order for there to be an issue of fact, the expert here would have had to say why contemporaneous medical evidence showed something different than he is seeing 4 years later. So the expert opinion put forward here by plaintiff is simply not probative because he does not take into account the contemporaneous medical evidence that we do have here.
And what about the degenerative findings in plaintiff's own records? Well, what's the import of that?
Sure. So a couple of things. So while there are positive MRI findings, this court has held several times that in itself is not enough for a serious injury under the insurance law. And because Dr. Berman's opinion was very thorough on finding that he both had a full range of motion by the time he was examined, and that these were degenerative in their origin, and that is not an issue that is rebutted by plaintiff's experts. So for those two reasons, there actually isn't an issue of fact on that. These were degenerative. And lastly, I would just like to point this court to its decision from 2019 in, I believe it's Diakite versus PSAJA, which is cited in our brief. And that case is identical proof to the one we have put forth here. And there, this court affirmed the grant of summary judgment. And we ask this court to do the same.
Thank you. All right, let's hear from Ms. Hilken for Antigua.
Good afternoon, Your Honors. May it please the court. I believe the counsel for the city has touched on many of my arguments. However, I think the main issue in this case is whether or not contemporaneous proof was submitted by the plaintiff. Now, if we look at Pearl v. Mayer did not eliminate the requirement for contemporaneous proof. It only eliminated the requirement for quantitative proof. So we still needed to have a qualitative assessment of plaintiff's injuries shortly after the accident. Dr. Zatsky's report he first examined plaintiff on July 14, 2017, almost 4 years after the accident. He didn't perform a contemporaneous examination. He does not review any of the contemporaneous medical records. And in this case, contemporaneous proof is actually very important because the emergency room shows full range of motion and no restrictions noted in the neck, back, or left shoulder. Not only that, but the plaintiff's own medical records from 11 days after the accident and I believe 2 weeks and 7 months showed that his range of motion was also within normal limits at his physical therapy office. So right now, all we have contemporaneously shows no restrictions, no range of motion limitations. So again, contemporaneous proof is crucial in this case, and we don't have any. And Dr. Zatsky doesn't perform an examination until 4 years after the accident. Now, he does address the MRI findings in his report. However, as counsel noted before me, there is case law supporting the notion that evidence of a disc injury alone without accompanying limitations is not enough to amount to a serious injury. Now, again, there are recent range of motion limitations in this case, but we cannot rely on those, and Dr. Zatsky can't rely on those because there's no contemporaneous proof. So I believe this court has held that recent limitations that are too remote in time cannot be considered for contemporaneous cases. And that's what we have here. These limitations were found 4 years after the accident, are far too remote to equal contemporaneous proof. So here we would argue the lack of contemporaneous proof submitted by plaintiff is fatal to his claim, and he is insufficient to raise an issue of fact. And we would respectfully request that this court affirm the lower court's decision granting our client summary judgment. Thank you.
Thank you. Mr. Friedman, 2 minutes. You have to take yourself off mute. Unmute yourself.
Oh, I apologize.
It's okay.
Now I
Go
will be
ahead.
quick.
You wouldn't be the first.
At least as to the excerpts of the physical therapy records that defendants relied on. Again, you can look at them. They start at page 425 of the record. I know that defense counsel says that they clearly state that plaintiff had full range of motion everywhere in them. I don't think that's clear, and you can also read the records to see that he still complained if pain was noted as having stiffness. So to say that there are no limitations, I don't think is completely accurate. The only other point I would make—
Mr. Friedman, to the extent you're claiming now they're excerpts, if they were somehow incomplete or they conveyed something that was inaccurate, you certainly could have put in the other records, right? They were your client's records.
I do agree, and like I said from the beginning, that's why I think this case mostly comes down to the issue of defendant's initial burden. And the only other point I will make on that is that both of their IME doctors referenced straight leg raise tests. However, Dr. Berman essentially just said the test was normal. That was it, no other support. And their neurologist, Dr. Carcienti, which I hope I'm pronouncing correctly, said that straight leg raising test was to about 80 degrees, which is normal. We cited at least 2 cases in our brief. In fact, one involving almost word for word the same finding by Dr. Carcienti, saying that those types of conclusions are not enough for defendants to even meet their prima facie burden. The 2 cases were Walker versus Public Administrator, Suffolk County. It's a Second Department case from 2009. And then there's Sherman, S-H-I-R-M-A-N versus Lawal, and it's a case from 2010. So essentially you have the defendant's doctors affirmatively putting it out there.
This is Judge Gonzalez, but I'm working with 2 computers so that I can look at documents. And I'm looking at Dr. Stotsky's report, and I'm putting aside the issue of it's not being contemporaneous. This issue of the degenerative condition that is raised by the defendants is referenced briefly, but it's not explained, and that could have been a really strong point. How does a 24-year-old have degenerative changes? But there's nothing here, and the defendants place great weight upon this, don't they?
I don't think they place as great weight upon it, or that they hadn't placed that great weight in the underlying summary judgment papers. Their emphasis was simply on the fact that they felt plaintiff had suffered sprains that they were resolved. But the basis for their conclusion, I think it's only Dr. Berman's conclusion that there's degeneration, because I don't believe Dr. Carcienti made that opinion. He just said there was no neurological impairment. Dr. Berman relied on some MRI reports that I don't believe are in the record, no films, and essentially said, well, these reports do indicate positive findings, but for one reason or another that's not clear, he thinks they're degenerative. So I don't think that the burden ever shifted to us or our own expert to contradict him on that.
Okay, thank you. Thank you all.
Thank you, Your Honors.
The next case is Baltic Fourth against Michael Stern.
Good afternoon, Your Honors. It's Paul O'Connor for the appellants. May I start?
You may.
Okay. Well, we're here on an appeal from Justice Ostrager's partial denial of appellant's motion to dismiss. And it's a very long complaint with a lot of counts. And so I'd like to start with alter ego and see how far I get with the time that I have. Justice Ostrager's decision on alter ego permitting claims to proceed against appellant Michael Stern in his personal capacity under alter ego or veil-piercing theories was simply incorrect. Respondents in their papers brag, and I've already mentioned how long this 13-count, 70-plus page complaint is. But frankly, that's the exact problem with the alter ego pleadings here. Respondents take almost every activity at the project over a number of years, borrowing money, paying contractors and employees, constructing the building, and then they stick an adjective like fraudulent or improper in front of it, and then they want Mr. Stern to be personally liable for that conduct because—
But counsel, this is a pleading motion, of course. Don't they sufficiently allege complete dominion by Mr. Stern?
No, I don't believe they do. They do. They do, Your Honor. I mean, again, if you look at the decisions from the first department, it's very clear that simply alleging that Mr. Stern has a position in an entity and that he somehow or another controls it, that he's in charge of it, is enough to allege domination. But I would like to say
also that he used them to commit fraud. You know, they obviously these are allegations, but they allege that he forged Tanakio's signatures and essentially used the joint venture to enrich himself.
Well, with respect, I mean, again, on the domination issue, we cited a series of cases in our papers that indicate that the allegations that they make are simply insufficient to allege domination and control. But even if domination and control was alleged, that's only one aspect of pleading an alter ego claim, and that is you need to indicate and you need to plead that that domination and control was used improperly to commit a fraud or wrongdoing. And with respect, again, this is what comes down to the fact that there's 70+ pages of allegations.
But counsel, let me stop you there. As my colleague was suggesting, there's a claim here that Mr. Stern forged Mr. Tanakio's signature.
Well, there is. Sorry.
So why don't you address that? I mean, isn't there a claim that he did commit fraud?
Well, first of all, the forging of his signature, which first of all didn't happen, but I take that it's
that's neither here nor there.
I take it's alleged. I take it as alleged and true for these purposes. But that has nothing to do with the alter ego allegations here. The alter ego allegations here are that he used his dominant position to somehow or another commit a fraud or wrongdoing that damaged Tanaccio, and that didn't happen here. Again, if you take a look at what was allegedly done here.
Well, what about who was the construction manager here in this case?
Construction manager here was JDS.
Okay,
JDS
and isn't the claim? I'm sorry, counsel. I'm sorry, but isn't the claim here that the fraud was that Tono was supposed to be the construction manager?
Well, no. I mean, no. If you look at the contract, which obviously is incorporated here, it's very clear that Tona Construction was going to be the initial construction manager, provided that the lender signed off on it, and then it also provided that the manager, JDS Construction, had the right to eliminate them as a construction manager at any moment for any reason or no reason whatsoever. So no, there isn't an idea here that they were going to be the construction manager. And again, the discovery has demonstrated in the case that the lender was not agreeable to having them serve as the construction manager, but sticking to the pleadings. There is no allegation in here that the lender consented to them serving as the construction manager. The facts are that the lender did not assent to it, but even if the lender had, even if we take just sticking with the complaint, there's no allegations in the complaint that the lender consented to it. So once again, that's not that's the problem here with 70 pages of all sorts of very, very, spurious allegations against my client using words like fraud and forgery, etc., in order to try to turn something that really is a breach of contract case into something different. Mr. Stern is simply an individual in some of these entities. He has a role to play in some of these entities. That's not a ground for piercing the corporate veil and trying to make him personally liable for a whole bunch of contract breaches, which is really all this is. All that's happening here is they've got breach of contract claims, and rather than pursue them against the entity that actually did the alleged breaches, what they want to do is try to get through the veil and make Mr. Stern personally liable. And I don't believe the First Department's law or the Court of Appeals law supports it. And I'd like to draw the court's attention to two cases that were decided relatively recently. The court's decision in particular in Aspire Music. And if you take a look at Aspire Music, that case was decided in February of 2019. Again, it reversed a decision of Justice Ostrager to let a alter ego claim go forward. And in there, this court noted that the complaint essentially alleges that Universal took advantage of Money's cash flow problems by helping to satisfy millions of dollars of Cash Money's debts in exchange for control of Cash Money, and then, through such control, paid itself higher distribution fees, thereby reducing the net profits the plaintiff was entitled to receive under the agreement. Well, these allegations describe legitimate business conduct.
Let me jump in a second.
Sure.
As to the distribution of funds,
Yes.
At the distributable funds, there was a water provision. How much money was tendered to Mr. Tenaccio and his company?
Millions, Your Honor. There is a debate about whether or not they're owed additional funds.
Was it the first 14, the first million, and then another million several months later, and then 14 million after that?
No, there's a dispute about the 14 million. That's the declaratory judgment claim. But again, yes.
I don't understand. When you say that millions were distributed, are you referring to 1 + 1 as in 2 million? Because I read here 16 million, but you're not saying 16, right?
I don't. That's their claim as to what they're entitled to. There's a dispute about that. There's a disputed declaratory judgment claim. We believe it's duplicative. We believe there's a lot of duplicative stuff here. That we think the fraud claims are duplicative. We think the claim for breach of the construction management agreement didn't comply with the terms and ought to be stricken. But I'll get to that. But if I could just get back to the alter ego
you're
stuff.
actually out of time, so I'm going to ask you to wrap it up, and you'll be able to address it on rebuttal.
Okay. Well, again, I'll just finish up on the alter ego point, which is the Aspire case, which I really would urge the court to look at. And a couple of members of this panel were on the panel that decided. So, well, not that case, but actually the Art Capital case, which also threw out alter ego allegations, because again, there was no allegation that the entities were created for improper purposes. And again, no one can say that JDS Construction, which is a large construction company that has projects all over the city and all over the country, was created for improper purposes. The same as to JDS Fourth. They don't even allege that it was created for an improper purpose. They claim they don't need to allege that. They can't allege that. Again, sorry, Your Honor, I think you're muted.
I'm muted, so I'll just stay quiet.
Okay. Okay. Well,
sure, really, wrap it up. You're beyond your time.
Okay, thank you.
Let's hear from your adversary.
Thank you, Your Honors. Mike McGowan from Westerman Sheehy for the respondents. As counsel noted below, Justice Ostrager found, as a matter of fact, he said on the first prong of the alter ego analysis, he found absolutely no doubt of Mr. Stern's complete dominion over the entities in question. And as a matter of fact, Justice Ostrager only cited 3 factors, but the complaint actually cites many more. JDS Fourth has no bank account. It has no capital. It commingled funds with JDS Construction. Mr. Stern induced JD Construction to contribute JDS Fourth's capital contributions to the project as he had to, because JDS Fourth has no capital, has no bank account. They all work out of the same address, along with the entity that took in a hefty 1.9 million development fee here, JDS Development. And Mr. Stern conducts business for all of those entities out of the same JDS Construction email account. So I think on dominion, it's pretty clear. As far as the second prong of the test, I think Your Honors have the gist of what we argue in our brief. The appellants are trying to say that the allegations we make only involve, quote, legitimate business activity, and as a result, there can be no alter ego liability. And Your Honors beat me to it, bringing up the forgery, because remarkably, in their 48-page brief, the appellants do not once mention the allegation of forgery, which is the very fulcrum of our case. It's not difficult to understand what our allegations are, regardless of the length of our complaint or, what is said therein exactly. Michael Stern, through his complete dominion and control of JDS Fourth and JDS Construction, The moment he forged that document and was able to move Tenaccio's construction management entity out and put his own in, just paved the way for the spree of financial malfeasance that followed.
Counsel,
And
if I understood your adversary's argument, he said that he's maintaining that your beef is that Mr. Tenaccio's company wasn't chosen by the lender.
well, what our beef is, Your Honor, actually, is that Mr. Stern never proposed our company to the lender. And if you look at page 294 in the record, Mr. Stern swore out an affidavit in an initial motion to dismiss before he knew we were going to make allegations of forgery, because we were unaware that he had forged these documents until defendants made their initial motion to dismiss. And as exhibits, they appended the forged documents. And at that point, our client said, I didn't sign these documents. And if you look on page 294 at paragraph 7, Mr. Stern concedes that there was an obligation in the joint venture agreement that Tona be the construction manager unless the lender would not approve of Tona. And he does not say in any fashion that he proposed Tona as the construction manager. He says, quote, the obligation to select Tona as construction manager never was triggered because a condition precedent under section 8.9 of the agreement, quote, the approval of the lender under the construction loan was not satisfied. We don't know whether the lender even knew about Tona Construction's existence. And in fact, Your Honors, the construction management agreement in this case, which was signed in April of 2016, 1 month before Mr. Stern forged the documents in order to close the construction loan, is signed by both Michael Stern on behalf of JDS Fourth and Michael Stern on behalf of JDS Construction. So it's obviously not an arm's length agreement, and it's something that Mr. Stern was cooking up well in advance of the construction loan closing. I just have one additional point, Your Honors, and then I'll rest on my papers. As far as the Aspire Music case goes, it's discussed at length in our brief, and it's completely inapposite here. There, Universal did not own Cash Money. They actually had entered into an arm's length transaction, completely unlike in the instant case where Stern owns and controls everything and nothing was done at arm's length. But they had an arm's length agreement between two companies that did not share ownership, and Universal was able to utilize that agreement to push the plaintiff out of a beneficial or advantageous position that they had been in their deal with Cash Money. So it's wildly inapposite to the facts here. It's an arm's length transaction, and Universal had no ownership of Cash Money. Unless there are any other questions from the court, I'll simply rest on our brief.
Questions, colleagues? All right, Mr. O'Connor, you have 2 minutes.
Okay, I'd just like to come back to the alter ego issues again and say that first of all, this spurious allegation of forgery has nothing to do with alter ego. I mean, again, this is trying to make our client look bad, but it has nothing to do with whether or not he was abusing the corporate form in order to damage the plaintiffs here.
So how should we consider that allegation with respect to the alleged forgery?
It's not in the alter ego context. It comes along later on in terms of whether or not they should or shouldn't be the construction manager. And what I would say there is this whole idea of a forgery, and somehow or another we forged it and we didn't tell the lender. I mean, first of all, with all due respect to my adversary now knows, because the lender has been deposed, that the lender in fact insisted that Tona Construction not be the manager. And the reason for that was because he didn't pass Know Your Customer regulations. And the reason they couldn't do that was because he had been involved in a Ponzi scheme. But I understand that's not in the record. But he said that they didn't know. They, of course, know. They know sitting here right now that, in fact, that happened. He's shaking his head, but he knows it. He sat through the deposition.
It's not true.
He took the deposition.
Counsel, I don't understand. Are you referencing something that's not in the record? Because if you are, you know we can't consider it, right?
I'm simply responding to something that was said, which is he said that he doesn't know whether or not, in fact, it was proposed. He does know because he took the deposition.
You still can't respond to, rely on things that aren't in the record. You know that. You're a good advocate. Go ahead, finish your argument.
Okay. Well, but moving on from the alter ego, again, there are fiduciary duty claims here under the joint venture agreement and under the construction management agreement. They were waived under the joint venture agreement. The construction management agreement is a contract, and you cannot have, and there are not fiduciary.
Counsel, that's not a blanket waiver, right? I mean, it said it doesn't know any fiduciary duties, but unless a party derived a personal benefit somehow. And in that case, there is a fiduciary duty, or there at least is a duty of care. So that's section 8.5 is what you're talking about.
That's right. I'm talking about section 8.
The pleading motion. They seem to have pled facts tending to show a personal benefit.
Well, but Your Honor, I don't believe that what that does is what the way that they're arguing it, that would read the fiduciary duty waiver completely out of the contract, because all you would need to do is plead fraud in connection with a fiduciary duty violation, and then the fiduciary duty violation would be meaningless. What that means is that—
I disagree with the second part of that proposition. You would have to plead fraud. That's right. That's right. And if you do, then we're not in no breach of fiduciary land. We're in a different land.
Well,
you have to prove it. You have to prove it.
Well,
there may be other reasons that the fraud is defective, but you absolutely right. It wouldn't render it ineffective. It would just say this is the exception where it doesn't apply.
Well,
all right, finish up your rebuttal.
Sure. In response to both of Your Honor's questions on that point, it would read it out of the agreement. They have it. They have a fraud claim. If they want to plead fraud, they can try to plead fraud.
So what is the purpose of the exception in the fiduciary? Let me finish my question. Sure. What is the purpose of having the except fraud to the no claim for breach of fiduciary duty? Why would you put it in there if it wasn't really an exception? Because you can always sue for fraud.
To make it clear that the fiduciary duty waiver didn't waive anything more than the fiduciary duty claims. It makes it clear that
fiduciary duty claims can be based on fraud. Sure they can. All right.
Well,
I think we understand your arguments, and we have your briefs.
Is the point.
Mr. O'Connor,
yes.
we thank you.
Thank you.
Thank you. Thank you both.
Thanks.
Okay, 26 Realty Partners against GSSN3 and Key and Lou against GSSN3. We're going to hear them together.
Good afternoon, Your Honors. Jeffrey Hursko.
Go ahead, Mr. Hursko.
Attorney for the appellant, 26 Realty Partners. Prior to addressing the argument, I think that there may have been some confusion on the calendar call. I am the only appellant. My client is the only appellant in this matter. There is no other appellant. I think Mr. Bilski responded that he was representing an appellant. He's in fact representing a respondent. And furthermore,
all right, I'll accept that if everybody agrees that's true. As you know, we got kind of a late.
Yes, Your Honor. There's some confusion.
Argument time. So when the argument time came through the clerk's office, that's how it was identified to me. And I'm not going to stand by it if it's not.
Well, we appreciate it and thank you for hearing us on this, because there was some confusion with the clerk's office.
There was confusion, and I respect that, and I think the court had something to do with that in terms of its recalendaring, which is why I was open to the idea of putting you in. So, but I just need confirmation from your adversaries, from, I guess, Mr. Bilski, that he is just a respondent here.
Yes, Your Honor, I'm a respondent in the 26 Realty Partners, yes.
Okay, thank you. All right, Mr. Hersko, you can proceed.
Thank you, Your Honor. So as Your Honors are aware, this appeal seeks the reversal of a decision in order of the lower court granting summary judgment to respondents and determining that the letter of intent at issue here was unenforceable for 3 reasons. One, that there was no privity between the contracting parties. 2, that the LOI did not contain sufficient essential terms to merit enforceability.
Counsel, who drafted the LOI?
Your Honor, that's actually a very good question. The LOI, and there's affidavits in the record that refers to this, that's actually a dispute as to whether it was prepared by my clients, 26 Realty Partners, my clients together with Samson Yarko, the principal of both GSS and KG and Don's. And that's one of the issues, the fact that it should have precluded summary judgment in this matter. As Your Honors are aware, the court sua sponte treated the motion, a second motion to dismiss, as a summary judgment motion. There's been absolutely no discovery in this case. And instead, the court made a finding that there is no contractual privity in the LOI between Samson Yarko, KG and Don's, and my client, 26 Realty Partners.
Can I, just a quick question. The LOI, can you identify me, what was the property that you claim was conveyed under the LOI, or was going to be conveyed?
Was proposed to be conveyed. So there's 2 parts to the property. It's actually, I believe it's laid out in the shape of an L. So they are joining in one corner. There's a vacant strip of property, and that there are air rights in the adjoining property. The adjoining property is already improved with a building. That building was the property that went into contract subsequently with Mr. Key and Mr. Liu. So
insofar as the property at 1098 University, that the letter of intent just covered the air rights to that.
No, just the opposite, Your Honor. 1068 University Avenue is the vacant land, and 175 West 165th Street is the property that's improved with air rights. So the air rights, as in the memo line of the letter of intent, which is in both records, I know it's somewhat confusing in the sense that there's been one order entered in 2 different courts, but the records are substantially similar, and the LOI permeates both records. It's a one-pager. It lays out the essential terms of the transaction. Primarily, the property is identified, the purchase price is identified, the percentage of the deposit is identified, the amount of time for due diligence is identified, the closing date is identified, the manner of payment is identified in such.
Counselor, this is Judge Singh. The part that confuses me, I guess, is how did KG come to be named, I guess, as the seller, to the extent that that's what's happening in this LOI?
So, Your Honor, in the record, there is a affidavit of one of the officers and/or directors of Appellate, in which he states his name is Mr. Shoshan, that this was done as a communication back and forth with Samson Yarko. Samson Yarko is the admitted principal, and this is indisputable in the record, of both KG and Don's and GSS N3. GSS N3 is, in fact, the record title holder of both of these properties. KG and Don's is a company that Samson Yarko is apparently affiliated with, and he was directing Mr. Shoshan in preparing this together with Mr. Nyarko to put the name KG and Don's into the letter of intent. Now, that is disputed by Mr. Nyarko in his 2 affidavits that are in the record. However, that clearly is an issue of fact, which should have precluded the court from making a determination that there was no contractual privity.
So are you seeking reformation? I mean, what's your claim here?
Well, the claim is for specific performance.
I understand that, but you need a valid contract. So are you seeking to reform the LOI?
Either under a theory of reformation or agency. Mr. Nyarko, for sure, was the principal of GSS N3. He himself has said that. There are similar cases cited to in the brief, in the reply brief. I think the one that's most similar is actually a second department case, Ty versus Dogwood, in which, in remarkably similar circumstances, a seller of real estate signed individually, while in fact the property was owned in a closely held family corporation, of which he was a 50% shareholder and the admitted president. The court then determined that that was therefore an issue of fact as to whether or not there was a reasonable basis to say that the signer of that in his individual capacity had authority to do so, and if it bound the company that was the actual title holder of the property. We would be making the same argument that Mr. Nyarko, in signing the letter of intent, signed it maybe either unwittingly or perhaps maybe even intentionally in the wrong name, and should not thereby benefit by evading the enforceability of the letter of intent by claiming statute of frauds. You got the wrong party.
So am I clear that you're not claiming mutual mistake then? What you're claiming is essentially a unilateral mistake allegedly tainted with fraud.
It certainly could be fraud. It could. Your Honor is correct in the sense that it could be mutual mistake if the other party didn't do it intentionally and said, "Oh, KG and Dons is the owner," and we put in the name KG and Dons based on that representation. I am not ascribing motivation to Mr. Nyarko. It may have been done unintentionally, may have been done intentionally, but that has something.
Are you also claiming, this is Judge Gish, that the LOI binds the owner of the property because it was signed by his agent with authority to do so?
Yes, and that's extensively in the record. The question is whether or not, I think it's raised in the opposition brief, which I'm sure that they'll discuss, is whether there was authority. But the fact of the matter is he's the admitted president of both entities. The admitted president of both entities certainly has authority.
Well, in any event, you couldn't decide that on summary judgment if he was an authorized agent.
That's correct, Your Honor. The issue of agency certainly is a fact-intensive issue that would require a fully developed record before making a determination. On the other two issues, I think the court determined.
Can I ask a question, counsel?
Sure, Your Honor.
With respect to the LOI and the language, once signed, this LOI shall be a binding LOI. Can the intention of the term once signed be determined without a full record?
Again, I don't know that it could be. I certainly think that it's pretty clear what once signed means. Just thinking of it logically, breaking it into pieces, it is impossible to be referring to the more thorough contract that's contemplated in the LOI, because how would the LOI be in effect once a contract is signed? The contract would be in effect when the contract is signed, and it would either supersede and or supplement the LOI. It certainly wouldn't be once signed, a document later that we have to do. There's retroactive status to the LOI that we're signing and saying in the second clause of that sentence that it's a binding contract. So I just don't think it makes sense logically when you add it up, the first clause, the middle clause, and the end of clause of that sentence. And I think that the court below, respectfully, got it wrong, because what they said was that was an ambiguous point in the LOI, and I don't think it's ambiguous. And to the extent it is ambiguous, Your Honor is absolutely correct. That's a discoverable issue. What was the intent here? Now, the court below said we can't rely on parole evidence. There is nothing left for parole evidence here. All the basic terms are met. The only terms that keep coming up, and I think was pointed out by the court below, are remedies upon default, tax adjustments. These are things that are inferred. There is no question. Risk of loss, there's New York statutes on risk of loss. None of those things are material to the basic terms of the agreement, all of which are very clearly identified.
Okay, Mr. Hersko, we'll hear from you on rebuttal. Let's hear from Mr. Bacon.
Thank you, Your Honors. Well, there are really 3 or 4 points here that I believe the court's already aware of from the record. One is there was no consideration for the LOI. For any agreement to be enforceable, there has to be consideration. Here, there is no contract deposit, and the appellant.
Well, wait, counsel. The deposit recited is 5%. The allegation is that Mr. Nyarko was acting in a particular way, so the seller at that point didn't wish to make the deposit. Isn't that really an issue of fact for trial as opposed to summarily deciding it on a motion for summary judgment without any discovery?
Not at all, Your Honor. The LOI is merely an agreement to agree, which is not enforceable. It states that the parties agree to enter into a contract, at which point a deposit will change hands at some future date once a contract is signed.
But then let me stop you there again. The LOI says once signed, it's signed. This LOI shall be a binding LOI.
Right. It's binding on the parties to then move forward and execute a contract, which the appellant did not do.
Well, it doesn't precisely say that. It goes on to say, and serves as an agreement of sale for the property and the rights at the terms referenced above. It's not precisely what you're saying.
But in the end, all it is a statement saying we'd like to enter contract. It's essentially an offer to go into contract, and it recites some basic terms. And had it been prepared by a realtor on a blank form, it would have recited all those same terms. But until the parties then negotiate an actual contract that recites the quality of title, that recites when the closing would occur, that recites what objections are acceptable and what exactly it is that's going to happen, until that happens, it's just a statement saying we agree to negotiate a contract on these basic terms. As somebody who's done plenty of real estate transactions, I've seen plenty of those kinds of forms not turn into a contract. It happens daily. Now, if every one of those documents was then enforceable by a buyer who later changed his mind and said, oh, I should have entered into a contract, it really was a good deal, and now somebody else is in contract.
But counsel, the allegation is that Mr. Nyarko thwarted the efforts to enter a contract. Are we to ignore that?
Well, unfortunately, there's nothing in the record that was submitted by appellant that would establish that.
Well,
and
was Mr. Nyarko deposed here?
Well, Mr.
That's just a rhetorical question. You don't have to answer.
No. But again, there's no reason for a deposition when there's a non-binding document that says we agree to eventually enter into contract, and then no contract follows. My client, meanwhile, is a bona fide purchaser for value who contracted to buy the building with the air rights, only to discover that there was an agreement to agree with no money in escrow, no contract, no title run, no effort having been put in by the parties to advance towards a sale. And now this purported buyer comes back and says, well, I want the air rights to the building you're in contract to buy. That
counsel, this may not be that important a fact, but I'm curious. The GSS N3 was the signatory was somebody named Mr. Agyapong. Who is that person? Do you know?
Do I personally know him? I don't represent GSS N3, so I would not.
No, I know, but I mean, just if you know in that contract who that person is, because there wasn't the contract between Pei Ki and Yanbing Luo, which I'm mangling their names, but was not signed by Mr. Nyarko. It was signed by another person. Do you know have any information about that other person?
That was the authorized person for GSS to execute that contract, as represented by GSS's counsel, Mr. Bilski, in drafting that contract. In that contract, there was actual lawyers involved who drafted an actual contract. Money went into escrow, and the deal moved forward with representations that at the closing, the title company would get adequate evidence that the signer is an authorized signer for the LLC. Now, that's all my client needs to know. My client went into contract and relied on that contract.
Okay, let's hear from Mr. Bilski now. Thank you.
Good afternoon, Your Honors. If it pleases the court, let me just correct one or two things in the record. Gifty, and I'm going to mangle the name as well, Agyapong is Mr. Nyarko's wife. She is the member of the LLC GSSN3, and that's why I presume she would have signed the contract with Pequot.
Can I stop you there, counsel? What's Mr. Nyarko's relationship to the LLC?
He's president of GSSN3.
Okay, so let's just carry that thread further now.
Okay.
As your adversary did. would agency or could agency be a basis to say, in fact, that it was signed on behalf of the right seller?
Let me, if I may, just correct the record one more time. I need to get this straight. I did not draft a contract of sale for Pequot. I was not Mr. Nyarko or Gifty Abpong's attorney for that contract of sale. I believe he had another attorney for that. If I may also just correct the record with respect to who drafted this LOI, it's clear from on the face of the document, the letterhead is 26 Partner Realty Partners. And it's addressed to Mr. Nyarko that this is to confirm our intent to offer. Clearly, Mr. Nyarko did not have any drafting with respect to this LOI. So I just wanted to correct those two things.
Okay, so I understand you corrected the record, counsel, but let me stop you. So it says signed by Samson Nyarko, KG and Don's Express Shipping Inc. How did Mr. Shoshan, if you know, understand, or whoever drafted it based on your version of the events, to put in KG and Don's Express Shipping?
I don't know the answer to that, Your Honor.
Is that an answer that we should know before we decide the appeal?
Well, the only thing, yes, I understand. But Your Honor, I think the issue before the court is whether or not the letter of intent satisfies the statute of frauds. You have, regardless of agency or any other theory of law, he's laid out four provisions here. This is a major real estate contract, and you have a purchase price, you have a deposit, you have a due diligence period that is ambiguous on its face. You have a closing date which is ambiguous on its face. There's no, if you recall, plaintiff sued for specific performance. Even if this was, there's no remedy for specific performance in this contract, even if there is a breach of contract, there's no remedy. So he could sue for breach of contract if this court determined this is a valid contract. But in fact, there's no specific performance was contemplated by the parties. They never agreed to any of these. They never agree, and that is, they didn't also agree to liquidated damages, that if 26 partners breach the agreement, that my client, Mr. Nyarko, or GSSN3, would be entitled to liquidated damages and keep a down payment.
Well, Mr. Bilski, this is Judge Gish. I understand that there's no provisions in there regarding damages, but do real estate contracts, in order to be effective, need liquidated damages clauses or a clause that entitles you to specific performance? Isn't specific performance, quite frankly, a law remedy in equity whenever real estate is sold? Based on
that's, Your Honor, every real estate contract and the forms drafted by the New York State Bar Association's Realty Group always has specific performance as a remedy for the,
we're not
and always has liquidated damages.
Good contract. We're talking about what should need to be enforceable. Nobody's, I certainly wouldn't argue that the LOI, even if it was a contract, was a great contract. But but my point is that you don't need those terms to satisfy the statute of frauds.
Well, Your Honor, the case law cited by Judge Thompson in his decision seems directly on point. In every single case, they found that a memorandum of sale or a letter of intent, if it did not include provisions such as adjustments of rents and taxes, default provisions. Where was the down payment going to be held? Was Mr. Nyarko, it was GSSN3 or KG Dons going to hold the down payment and not an attorney? There are so many provisions here that are missing that it's clear that you can't enforce this, the bare bones or an outline of an agreement. And I look at Judge Thompson's decision, and all the case law that he cites to is directly on point.
Okay.
Counselor, this is Judge Singh. Can't those terms that are missing be supplied by operational law, custom or usage?
I'm not sure how you can do that. If you think about it, right now there's an under $870,000 lien against that property. So with 26 realty partners, is going to buy a property for $430,000 with an $870,000 lien against it that is currently in foreclosure. In any real estate contract, it's all, unless you waive it or you strike it out of the contract, a real contract. It says that the property key provisions, material terms, are that it's delivered as is, and it's delivered free of liens and encumbrances. Why? That's why you have title companies searching the records to make sure that when the buyer gets it, that he's getting it free and clear, that there won't be someone that comes out from 80 years ago and says, no, I own a part of that property, so I'm going to assert my rights. That's the very reason why you have all those provisions in any real estate contract. That it's clear that from this letter of intent, what it's saying is yeah, look, we want to buy your property for $430,000, and let's do this. In a future date, we'll sign a contract with more of all the terms, including the material terms of how they're going to pay, where's the deposit going to be escrowed, what are default remedies for both parties, whether or not GSSN3 has to deliver it free of liens and encumbrances, who's got risk of loss. There's so many terms in a real estate contract that are missing here that Judge Thompson is absolutely correct, and this case law supports it.
Thank you. Mr. Hursko, you have rebuttal.
Thank you, Your Honor. I guess I'll address Mr. Bilski first. I just want to note for the court, there is absolutely no brief filed by respondents Nyarco, GSS, or KG and Dons. But in any event, in the decision of the lower court, I think the court relied on 2 or 3 cases. We clearly distinguished those cases in the briefing. And what was abundantly clear was that the few cases that the judge did rely upon were diametrically inopposite to the case here. In those cases, the property itself was not identified. The terms of payment were not identified. There were supposed to be purchase money mortgages. With respect to the fact that the property may or may not be marketable at the end of the day if there's a larger mortgage. We don't know this. There's going to have to be discovery. Even if there's a face amount mortgage on this property in excess of the amount of consideration used for the purchase, we don't know what's owed. And in addition—
But by the way, Mr. Hursko, there's no prohibition against selling property with bad title.
That's correct.
Unless you make a representation in the contract that you're selling good title, right?
Right. So cited to in our brief as well is that title is presumed to be marketable. That's the law of the state. And in fact, we do not know if that blanket mortgage, because it covers both properties, has a partial release provision. We have no idea. That could be in a separate agreement. That could be in the note. Perhaps if we pay them a certain amount, they will release it and we could get clear title. The bottom line is that discovery was not done. And because discovery was not done, all these other questions have to wait for a later date. We need to know, we can't do this analysis by just saying, well, KG and Dons was not an agent of GSS, and therefore the LOI is unenforceable. With respect to Mr. Pakin's claims about no consideration, first of all, there's plenty of case law cited in the briefs. I won't belabor the point, but a deposit is not mandatory for the purposes of having an effective contract. It's not an agreement to agree. We've been through this. It says once signed, it's an LOI and it's binding.
Well, the consideration would be the payment of the $430,000 that you'd be obligated to pay if it was an enforceable contract.
Correct.
Counsel, is it
So
fatal?
I'm not sure I understand the consideration argument, quite frankly.
What about the absence of the lien? No mention of it in the letter of intent, counsel. Is that fatal?
No, because again, title is presumed to be marketable, and it would always be at the, as Mr. Pakin addressed, he does real estate contracts. I too do many real estate transactions, commercial and otherwise, and we will always have the opportunity to accept unmarketable title at a closing. That's the purchaser's right. If the purchaser wants to waive the fact that it's not marketable, if there's a title exception which makes it uninsurable, perhaps raising exceptions to a fee policy, that's the purchaser's right to do. So,
in fact, counsel, have you reviewed I have not myself, the contract of sale between GSS and Peiki and Yanbing Luo? Does it mention the lien, alleged lien?
Your Honor, I do not know.
If you know, I don't mean to make that a trick question. I'm just wondering.
No, I do not know the answer to that question. I could say, to point out one further thing, I think it was Judge Singh that asked who that other party that signed the contract was. It's eerily similar then to this case, this Attai versus Dogwood Realty case, in which the claim was, well, my wife didn't agree and she's the other 50% shareholder of the company, and therefore I didn't have authority to do it. So the mere fact that they're married, I think, it furthers the point that there should have been authority, and in the event that there's a question of authority, then it's a summary judgment analysis, and the court applied a completely wrong standard for that.
Okay, thank you. Thank you all.
Thank you, Your Honor.
The next and last case is Goya. Let me just set up for that. The first appellant is going to be Longwood. You have 6 minutes. Okay, you can begin.
Good afternoon, Your Honors. May it please the court, Dana Catanzaro of Litchfield Cavo for respondent appellant Longwood Housing Development Fund Company Incorporated. I know this is a very complicated group of appeals and cross appeals. I will go one by one per party and per indemnification and breach of contract claim for the purpose of clarity, unless the court prefer me to do otherwise. Preliminarily, the lower court erroneously denied Longwood summary judgment on its breach of contract and contractual indemnification claims against AIM and Clark. AIM is not here today. They're not represented by counsel. The prior counsel for AIM moved to be relieved, and that motion was stayed until October 19th. They have not received new counsel. Unless the court has any questions with respect to our appeal as it pertains to the claims against AIM Construction, I will rest on my papers. With respect to Clark and Wilkins, the lower court erroneously denied summary judgment to Longwood on its claims based on both contractual indemnification and breach of contract. With respect to the contractual indemnification claims, pursuant to its contract with Triborough, Clark expressly agreed to indemnify Longwood for any claims arising out of or resulting from its work. The lower court erroneously found an issue of fact with respect to whether the accident arose out of Clark's work, because Clark alleged that it only performed work on the fire escapes and not on the ladders. However, Mr. Americo Lamari, who testified on behalf of Clark, testified that his work included inspecting the fire escape ladders and making sure that they went.
Can I stop you for a second?
Yes, Your Honor.
The claim for indemnification, have you shown that your client is free of negligence in this case? What obligations, specifically now referring to the testimony of the super, does your client have with respect to the ladder, which allegedly was the cause of plaintiff's injury?
Your Honor, with respect to any alleged negligence on the part of Longwood, the lower court dismissed the Labor Law 200 or codification of the common law negligence claim against Longwood. So I do believe that it's the now law of the case that there was no finding of negligence on the part of Longwood. And it's been established in the record that Longwood did not supervise or control any of the work. This was a means and methods labor law case and not a premises case.
So that's the argument, that it's based on means and methods and not premises liability. Isn't there a basis to argue, in fact, that there could be premises liability here, based on the super's, I think it was monthly that he inspected the ladders?
Yes, but the issue here is not whether there could be, but whether the record in fact shows that there was. And I believe the lower court properly found that there was no finding of any negligence on the part of Longwood. And there is testimony from the superintendent who testified on behalf of Longwood. There is testimony from Triborough, there were no complaints. There was no
So the
notice.
super testified that he checked the ladders monthly to make sure they were operational and there were no complaints. And then there was a period of time that he wasn't checking them because there was I guess work going on the apparatus, correct?
That's correct, but at no point in time was there anything that was discovered with respect to the ladders not working properly. And that goes for not only the testimony of those parties, but also the multiple investigation reports that were established in here. It all goes to plaintiff slipped when he was ascending the ladder. Plaintiff was not provided with any safety devices, which I believe renders this very clearly within the ambit of the means and methods case.
This is Judge Gonzalez. But if the building superintendent was inspecting the ladder and the fire escape every month and didn't do so for 2.5 months prior to the accident here, then do we have an issue of fact as to possible negligence?
I don't believe so, Your Honor, because for the very purpose of inspecting the fire escapes and the ladders, this work was contracted to a specialist company who performs this work. And that is one of those contractors is Clark and Wilkins, and they agreed to indemnify Longwood for any claims arising out of their work. And as this falls within the scope of their work,
the owner delegate that responsibility?
Yes.
But you can't indemnify for Longwood's negligence. I guess that's really what my colleagues are getting to. And I understand the means and methods, but the question is, doesn't this have elements of possibly a premises condition liability as well, given that there's some claim here that the ladder was defective and or slippery? And how could you, and if your client had notice of that as the owner, wouldn't they be responsible directly to the plaintiff, and therefore the indemnification wouldn't kick in?
Under that set of circumstances, Your Honor, then, theoretically, yes, I agree. However, that is not the facts that are clearly established by the record here, which is why the lower court found that there was no negligence on the part of Longwood in dismissing the Labor Law 200 claim. There was no complaints. There were no complaints by plaintiff, by any of the workers, that there were any issues with this ladder. Plaintiff's testimony that he slipped, again, lends to the argument that the accident arose out of the way plaintiff was performing his work, or because he did not have adequate safety devices, not because of the premises condition.
Your time has elapsed, and I know you haven't reached all your arguments, but we do have your briefs, and you'll have a few minutes on rebuttal. So let's hear from Melcara now.
Good afternoon. May it please the court, Sim Shapiro from law firm Baxter Smith and Shapiro on behalf of Melcara. My client here is a construction manager. That's not only what the contract says, that's also what all the witnesses say. In terms of in the construction phase, their responsibilities are limited to schedule coordinating. There are cases out there.
Counsel, this is Judge Singh. Is that all that was testimony? Wasn't there testimony from your senior project manager about the ability to stop unsafe practices, for example? And could that be a basis to suggest that you may be a statutory agent?
Not in itself. That alone would not be sufficient. And again, he actually testified, the same witness testified that they had no supervision at all over ladders and painting and that type of activity. So in terms of that witness, it was very clear from just that alone that this was outside of their purview. So this is a construction manager. There are definitely work sites where a construction manager is tantamount to a general contractor. This isn't that work site. We have another company that's here represented by counsel that has openly acknowledged that they were the general contractor. So
but you could have more than one statutory agent, can you?
You could, but in my client's case.
Okay, all right, let's stop there for a minute. So then the question is, are there facts related to the duties that your client performed, or at least issues of fact, that would arguably bring it within the purview of a statutory agent? One of them, my colleague, Justice Singh, mentioned the overseeing of site safety, but they had more than that. They also retained authority to give directives to AAD's designated representatives. And didn't they also have the ability to hire the subs on this, the contractors? Would that bring it within the purview of a statutory agent?
The only contractor they hired was AD to be the general contractor. It was AAD that actually had the responsibility to hire the subcontractors. And they actually testified, there was testimony that they didn't even make so much as make a suggestion as to which subcontractors would be hired or to have any control over the area or this within their purview of the kind of work that was being done by the plaintiff. I'll go so far as to say not only the plaintiff, but also the CEO of the plaintiff company testified that they'd never even heard of my client. So I would go so far as to say in the context of this case, I can't say there's no case where you could find where there's another statutory agent besides a general contractor, but this is not the case. I know my time is limited, so I do want to just address one other issue because, which is anti-subrogation. We have a company that, by their own admission, and there's really no dispute, is being has had their defense and indemnity taken over by my client's insurance carrier. That is classic black letter anti-subrogation law. For some reason, they have argued that somehow this is different, albeit with no support whatsoever to say, well, there's a contractual indemnity claim and they're not contractually indemnifying us. Respectfully to my honored colleague, I'm not really clear what they're even meaning by that.
When did they take over the defense?
From day one. From day one. That's not even up for discussion. That's they say it in their own papers.
So in other words, they've taken over the defense, but they haven't agreed to indemnify. Would that change the anti-subrogation rule?
That's also not up for debate. What they're saying is on the contractual indemnity claim.
Oh, wait, no, just be clear with me. I want to understand. Has the insurance company agreed not just to defend, but also to indemnify?
Absolutely.
Okay, thank you.
From the start, that's been the case. They acknowledge it in the papers that they're an additional insured under my client's policy. That is, by definition, that's the poster child for anti-subrogation. Then they go so far as they bring up excess coverage. They've got no evidence that they so much as tendered to the excess carrier or that there was a disclaimer on coverage. But even if that was correct, all it would mean is the claim should be dismissed without prejudice over the policy limit. They've never shown any indication that they're not covered on their policy. And the bottom line is that they're being paid for by my client's insurance carrier here. So that's anti-subrogation. And respectfully, at the very least, that claim's got to be dismissed. And certainly they should not be they've essentially gotten summary judgment on their fellow insured. And obviously that would need to be reversed. I do want to just one quick point that in my 4 minutes.
You're out of time and you're going to have some rebuttal, so you'll be able to bring it up then. You're one of the ones that gets rebuttal. Let's hear from AAD, Mr. DeCamp.
Yes.
Mr. DeCamp.
Happens all the time. I'm used to it. No problem. Jerry DeCamp for Appellant Respondent AAD Construction Corporation. As your honors already touched upon, the lower court should not have granted summary judgment on its contractual indemnity provision against AAD because there are clearly issues of fact here with respect to Longwood's own negligence. They are a in possession landowner of this premises. They had a duty, and it's a non-delegable duty, to maintain that fire escape ladder that is part and parcel of its property. There's testimony that the superintendent was doing monthly inspections, and then for 2 to 3 months he did not. I mean, something else the court should know is that at the time that this work was going on, this was also a residential building where residents were still living. So that fire escape there was still his duty to maintain it, not only for the workers that were there, but for the residents of the building. So
is there any evidence or at least an issue of fact about whether it was defective, whether the ladder was defective?
Plaintiff's own allegations in his testimony that it shook and it fell and that he couldn't pull it down the full length to the ground. Whether or not you believe his testimony, that's his testimony, and that's going to be for a jury to decide whether or not that's sufficient to constitute. So
yes, this would be a premises liability and not solely a means and methods. as far
Correct,
as
Your Honor.
you're
This is not
concerned.
a solely a means and methods case. If anything, it's more than, if you look at plaintiff's bill of particulars, he claims throughout that this was caused by a defective, dangerous, and unsafe ladder, meaning the fire escape ladder on the premises. So this is a defective condition case, not a means and methods case. So unless Your Honors have any questions to that, I'm just going to move on to the lower court's grant of breach of contract to Longwood as against my client AAD. There has been absolutely nothing in the record showing that Longwood even tendered to my client's insurance carrier, Commerce and Industry Insurance Company. My client has procured the requisite commercial general liability policy with the requisite additional insured endorsement and turned it over. At the end of the case, Longwood didn't just file the motion for summary judgment saying that AAD breached its contract, but the insurance has been procured, the policy has been produced, it has the requisite additional insured endorsement, and it looks like now at this late stage of the game, they have not even tendered, nor has coverage even been denied. But even if it were denied by the carrier, then that is really the substance of a declaratory judgment action to be brought by Longwood as against Commerce and Industry Insurance Company. Last point I have, I was an appellant on those motions, but I'm a respondent with respect to Clark and Williams motion, seeking to have the common law and common law contribution claims dismissed as against it. The lower court was correct in denying it as Clark and Wilkins was ultimately the entity that was responsible for making the requisite inspection and repairs of that fire escape ladder. And just the mere fact that plaintiff is claiming that it was defective and it was not properly inspected or repaired raises an issue of fact, and the lower court was proper in denying Clark and Wilkins' motion.
Thank
So
you.
unless Your Honors have any questions for me, I will rest then on my brief.
Okay. All right, we'll hear next from Clark and Wilkins.
Good afternoon, Your Honor. I'll start with the last point first, and unless there are any questions, I'm perfectly happy to see the rest of my time and rest of my brief. All the testimony says that the ladder was inspected after Clark and Wilkins' work was completed. The plaintiff's accident happened 3 months later, and the only testimony that any party can point to contradict that is the plaintiff's own admittedly speculative testimony in which he says, "I imagine that's what happened." The motion Clark and Wilkins should not be in this case. They completed the work, it was approved. The ladder was used, no problems were found with it for 3 months. And then whatever caused the plaintiff to fall, but it was not a defect in their work. If there are no questions, I'm perfectly happy to cede the rest of my time.
Any questions, colleagues? Okay, thank you. All right, cross-contracting.
Good afternoon, Sarah David, on behalf of Cross Contracting. I'd like to address an issue that has not yet been raised, and that is the overarching error with respect to my client, insofar as the underlying decision improperly held that the prime contract, which is 4 layers removed from my client's only contract in this matter, which was between Cross Contracting and Clark and Wilkins, that the prime contract can somehow be incorporated by reference into this subcontract between my client and Clark and Wilkins to impose risk transfer obligations on my client to the owner of the property, Longwood. This is simply at odds with all of the longstanding New York case law concerning the incorporation by reference into a subcontract.
Let me ask you a question. There was an express provision in the contract that provided for additional coverage for an owner, period? Right?
It did.
Yes?
No, the contract does not. It expressly does not provide for additional insured coverage to the owner. And if you look at page 1705 in the record, you'll see that the only party for whom my client was required to procure additional insured coverage was Clark and Wilkins. That is expressly a misstatement. It is a misquote. It's an error in the briefs and in the motion papers on behalf of Longwood. With respect to the contractual indemnification obligation that the underlying court found my client owed to Longwood, that too is an error. As this court held in Wadkiss and its progeny since 2008, the only incorporation by reference with respect to a subcontractor is as to the scope, quality, character, and manner of the work to be performed. Longwood is trying to redefine scope to mean not scope of work, but rather scope of an indemnity obligation. And that is simply not in keeping with the New York law.
All right, so, and in this case, that provision provided for the owner, correct?
So this contract between Cross Contracting and Clark & Wilkins was actually executed a year before the prime contract in this matter. This was an ongoing relationship between Cross Contracting and Clark & Wilkins for various projects at various buildings. So the argument that we can somehow find a definition, first of all, we can't incorporate the definition by reference from the prime contract for the reason that I set forth a moment ago, because it's a risk transfer obligation that you can't.
But what does it mean then? It sounds to me like you're reading out the provision of indemnification of an owner in that contract. What does it mean? Who would be the owner?
Well, it's not specific to this property. That's the point. This is not.
It would never be specific to any property. So who would be the owner? Well, what's the obligation?
The obligation might have been with respect to the other properties that were
wouldn't they have the same problem that you're articulating here? You're saying nobody's named, it just says owner. You can't reference anything back to figure out what do you mean by owner. So it's basically you're telling me that provision is unenforceable. It has no meaning.
No,
it has enforceability.
Even assuming that that's the case, and I don't necessarily concede that because I would argue that it applies.
And I'm going to ask you, when would it be enforceable? That's what I was asking. Tell me when.
When the owner is specifically defined.
Well, it would never be specifically defined because the contract is the contract. It doesn't define.
Yeah, and the parties aren't clairvoyant. They don't know what contracts are going to be entered into in the future.
Arguably, there were contracts in existence between Clark & Wilkins and other entities for which it was performing work at the time that the Clark & Wilkins subcontract.
And there would be a reference back, and you're saying that's unenforceable to define owner or to identify the owner.
If I may just address the next related argument to this.
Sure.
So even if we assume, arguendo, without conceding it, that we can define Longwood as an owner who was supposed to have been indemnified, the second level of test that the court failed to do to analyze in determining whether or not my client owes this contractual obligation needs to decide two things. First, that Longwood has no negligence, which, as my colleagues have already said, it can't do. And second, that the plaintiff's accident arose out of or in connection with cross-contracting's work at this property. That's the language in this indemnification provision of the cross-contracting contract. So if we're going to say that that provision applies here, those two tests had to have been done by the court, and they were completely ignored. The court simply said that we incorporate it by reference. Longwood's entitled to summary judgment on that claim, and that's improper. If I may quickly, cross-contracting
very quickly because you're out of time. So
I know, and I don't get rebuttal, so I'll just be really quick. My client's work was completed.
Go ahead.
My client's work was completed in April of 2014, 3 months before plaintiff's accident. After my client completed its work, it was inspected and approved by Triborough, and Longwood resumed its ongoing monthly inspections to ensure that the fire escape was working properly. At no time in Triborough's inspection, in Longwood's subsequent inspection, or in plaintiff's use of the ladder in the 2 days leading up to this accident, did anyone have a problem or find a problem with this ladder. No one had notice of it. If Longwood didn't have notice of it after it was doing these inspections in April and May, and plaintiff was using it in early July, in the days before this accident, how could my client, who hadn't been on the premises in 3 months and had no duty to be on the premises, possibly have notice of a condition or have noticed that its work was somehow improperly performed, which, by the way, there's no evidence of. The only evidence in the record relating to my client's inspections is the expert submitted by Clark & Wilkins, who says the inspection was properly performed in keeping with industry standards. It was approved, it was inspected, it was paid, and my client was discharged from the site. My client simply cannot be found to have done anything to cause or such that the plaintiff's accident could be found to arise out of or in connection with Cross's work. My client should be out of this case entirely. All of the claims and third-party claims should be dismissed. Thank you.
All right, Mr. Isaac for the plaintiff.
Okay. Good afternoon, Your Honors. Brian Isaac and Judge Gish. I'm going to try to actually stay under my time. You'll be happy to know that I did not submit any briefs on the indemnification issues. So let me just
Shocking, right?
Let me get right to it. With respect to AAD's claim that this court's prior decision denying their motion is not collateral estoppel in law of the case, that's just not right. It doesn't matter what happened with respect to subsequent discovery. This court's foreseeability jurisprudence with respect to 240 of the labor law, I'm talking about Jones against 414 equities and Ortega, make clear that foreseeability is only an issue when dealing with something that can't be physically seen. When you're dealing with objects that involve obvious elevation risks, like ladders, like scaffolds, like risers, like hoists, that's not the issue. And if you look at the Jones against 414 equities, a case I know, you probably realize that I lost that case spectacularly. On page 79 to 80, there's a specific explication of the law which refutes AAD's assertions. With respect to the 241-6 claim, AAD claims that the plaintiff's testimony is less than coherent and is contradictory. It is, but that's an argument for trial, not for summary judgment. If you look at page 44 of our brief, we cite to Mr. Lamari's testimony where he says, quote, "I still don't understand why plaintiff was there on a day it was raining," and Mr. Avatabli's statement on 1558 that it had rained the night before and into the morning on the day of the plaintiff's accident. And I think when you know that 12 NYCRR 23-1.7D does not have a storm in progress exception, so I think the trial court got that right. With respect to Melcara's appeal, all I would say is if you look at the record, some of the judges have spoken about it. Mr. Pavlicek, Melcara's senior project manager, specifically stated on 1940 to 1941 and 1960 that he could stop work if he saw a worker working without a harness. If you look at 1876 to 1878, which is cited on page 34 to 36 of our brief, you see that there are broad control provisions with respect to Melcara in which they coordinated, supervised. There's even a clause in there that they have responsibility to comply with statutes, rules, ordinances, and regulations. We would simply rely on Walls against Turner Construction, 4 New York 3rd 861, to establish not that we necessarily win, but that there's at the very least a question of fact on those issues. And if there's nothing else, I'm happy to stop talking and let you get on with your day. Thanks for listening to me.
Any further questions, colleagues? Okay, Triborough.
May it please the court, I'm Frederick Klein from Sullivan & Klein for Triborough. I do want to briefly address Ames' appeal, even though they're not here. Can you hear me?
Yes, we can.
Okay, good. Sometimes people can't. Under the two-part analysis of Rodriguez versus NNS building contractors, there was a valid indemnification provision in the contract between Triborough and AIM. The agreement was applicable to this site. The indemnity provision was particular and is in fact similar to that in the Rodriguez case. And in both the Rodriguez and this case, the employer took responsibility for the safety of the employees. In both cases, the employers, that's AIM, took responsibility, procured insurance that was supposed to protect the one that hired them, Triborough. There's been no determination that Triborough was negligent. It's disputed. And AIM is incorrectly asserting that the indemnification provision has no savings clause. If you look in the record of their record at 1044, it's very clear that it does. It's in the same sentence as that addressing attorney's fees. Regarding Melcara's appeals, I don't want to repeat what people have said, but I do mention that their senior project manager, Mark Pavlicek, did say that he could stop the work. The labels of general contractor or construction manager are not dispositive under the case law, including Miles versus Claxton. Walls versus Turner has already been cited by plaintiff's counsel. Plaintiff testified that he received instructions from supervisors who he was not able to identify, but we know that Melcara did have supervisors at the site, John Singh and Mark Pavlicek, both of whom have testified.
So you're arguing, counsel, that there's an issue of fact?
That's correct. And regarding Clark and Wilkins' appeal, it's been mentioned that the work was looked at after Clark and Wilkins and actually crossed, since it was the same people under different names doing the work. Those inspections were not a guarantee of Clark and Wilkins or Cross's work. People were looking at, from Triborough, from Melcara, they were looking at the work just to see that it was done. Mr. Abatable of Triborough said that he looked at the work using binoculars just to see that because he could tell from what paint was on it, from orange on the fire escapes, that work was done. Mr. Lamari testified that there were issues with fire escapes being damaged in the Bronx because of trucks hitting them, so he was aware of the risk. He assumed the duty and tort to exercise reasonable care as to his inspection to prevent foreseeable harm to others or to users. That's Sands Zone versus National Elevator Inspection. Now, regarding the issue of insurance, we argue that Clark & Wilkins has produced no documents evincing that it fulfilled its duty to procure the insurance in compliance with the subcontract agreement with Triborough. Triborough was supposed to be an additional insured. They only produced one insurance policy, Northfield, which contains exclusions for contractual liability and insured's injuries, which is contrary to the contract. And as far as it was mentioned before, the expert report that was submitted by Clark & Wilkins, that expert report was based on an inspection by the expert years after the events of this case. So the conditions of the fire escape could not have been the same or may not have been the same. So that expert report, if anything, just creates another issue of that. I know I'm under my 7 minutes, so if there are any questions, I'll take them. Otherwise,
Any questions, colleagues? Okay, so let's hear a rebuttal from Longwood.
Thank you, Your Honor. Sorry, I just needed to unmute myself. I'll try to go through these as quickly as possible since I have limited time. I do echo Mr. Klein's sentiments with respect to the parties inspecting, just to make sure the work was done and not for any conditions, as that work was contracted to Clark and then subcontracted to Cross. First, with respect to Malcara's allegation that Longwood is not entitled to contractual indemnification based on anti-subrogation, we note that Malcara did concede that the doctrine of anti-subrogation only applies up to the policy limits. Longwood is entitled to contractual if the verdict exceeds the policy limits. Second,
say that again. I'm sorry, I didn't catch that. What is your argument about the anti-subrogation?
So that Longwood is entitled to contractual indemnity to the extent that there's a verdict that exceeds the policy limits. So this is not the venue to determine whether they obtained the insurance. This is not a declaratory judgment action, but because of they did not obtain the insurance that they were required to obtain, and the indemnification can exceed the verdict can exceed the amount of the policy.
Why wasn't the insurance conforming?
For Malcara, they were, sorry, Your Honor, with Malcara, the contractual indemnification is the only issue that they spoke to, but they ignored the provision that holds it responsible for the work of its agents or contractors.
So let's understand this. Are you conceding that to the extent that there isn't an excess verdict that the anti-subrogation rule applies?
Yes, but
okay,
that is why
all
they
right.
need
So
to
just
identify
explain to me, and it's my own ignorance. How would that work then?
Your Honor, if I may, I'd just like to rest on my papers for the remainder of that, as I have such limited time.
I'll give you extra time. Explain it to me. I need to know. It's anti-subrogation is always very confusing. You're admitting that you tendered a defense. They took it up. They said they're going to indemnify you up until their policy limits. So what else? What else could you possibly get?
We would only be entitled to indemnity then for the amount of the contract, for the amount of the insurance policy, and not for any excess of the verdict. If there was a verdict, let's say a $20 million verdict in this case, then we would.
Counsel, this is Judge Singh. Have you reached out? Have you tried to make a tender to the excess or do anything with respect to the excess? It may be premature. I'm just wondering.
Your Honor, I'd have to just go back to my notes or to the record to determine whether there was a tender to an excess carrier. But as counsel indicated, they're not admitting to any obligation to indemnify us over the terms of the policy, and that's where there's the issue, because it should not be limited to the terms of the policy. They agreed to indemnify and to provide insurance, and that should apply to any verdict.
Oh, but I'm sorry, wouldn't that require you to do something then, if that's the case? I mean, maybe take out a DJ action against the excess, make a tender, something, as opposed to saying anti-subrogation doesn't apply for that reason.
Well, it doesn't apply because there is no verdict yet. So it's premature in that sense, but to the extent that there is a verdict in excess, there should not be a limit. And that's based on the terms of the clear terms of the contract that are, and as we detail in our brief.
But right now they're giving you a defense and there's no verdict. And your client hasn't elected to otherwise hire its own counsel in the event of an excess to co-counsel with them.
At this point, no, Your Honor.
So why, I still, all right. Okay.
And I would just like to address Cross's argument with respect to the contract, and several things going into that. As the court mentioned, the court's purpose is to interpret a contract, so to not render it meaningless. With this contract and many other contracts that reference an owner or incorporate another contract by reference, they would all be meaningless if in this case Longwood was not identified as the owner because they were not expressly listed as the owner in the contract. And at no time before did Cross even argue that incorporation clauses are invalid and unenforceable with respect to indemnification provisions. So that hasn't even been preserved for appellate review. I'm
sorry, I don't understand the argument. I thought the argument was that the incorporate by reference doctrine only applies to scope, quality, character, and manner of the work, right? That's the argument. And is that wrong? Isn't that correct argument?
Your Honor, let me clarify. I apologize. The contract, Cross's contract incorporates the prime contract in which Longwood is identified as the owner. And that pertains to the scope of the work, and especially because Cross has this contract with Clark that predates the work that it's doing in many locations. This would not just be an issue in this case, but in any case that arguably Cross is doing work pursuant to a prior contract, then there would never be an owner identified in any of those contracts. And I believe the lower court properly found that based on the record, that Cross referenced Longwood as owner by incorporating the terms of the prime contract. And the other final issue that was raised was AAD's argument of, again, with respect to this being a premises liability case, and some of the other parties have mentioned this as well. And I would just like to point out that with respect to that, none of the parties appealed from the portion of the order that dismissed plaintiff's Labor Law 200 claim against Longwood. And I think the reason for that is, and as the court can see from the record, is that the record is clear that there was not a premises condition and there was no notice. And there were parties that were there to inspect the condition, and that was Clark and that was Cross. And pursuant to those contracts, if there was any negligent condition with the latter, it was up to those parties to determine it. And that's why we should have contractual indemnification. And the court properly did grant us contractual indemnification against certain parties in light of this arising out of their negligence and not Longwood's negligence.
Okay, thank you. Let's hear from Melcara, rebuttal.
Not every day that I agree with my esteemed colleague, Mr. Isaac, but I have to agree with him on that. Part of this court affirmed a ruling from the lower court, which I do think is binding from a previous motion. That included language that said, pursuant on page 2019 of the record, pursuant to the terms of Melcara's contract, he and John Singh, the other Melcara employee, were not authorized to direct or control the plaintiff or his employer. Plaintiff produced no evidence to refute that. So, in fact, it's actually law of the case that my client did not have such authority. I'll also point out, because the question was asked before, in terms of Mr. Singh's testimony, he testified, it's on page 1022 of the record, that his work, the project that they had, did not involve the fire escapes at all. So this is really outside the scope of what they were doing. Lastly, to answer your question, Justice Gish, vis-a-vis the anti-subrogation, you asked how would it work? And the answer is it wouldn't. And that's the whole point of anti-subrogation, which is they're being defended under my client's policy and indemnified, so they can't sue them for contractual indemnity. And in fact, the record doesn't contain any tenders to the excess policies, but above me on that, I cited to the Mitchell case, which actually was my case in the 4th Department. And this case, their claims are dismissed at least up to the limits of the policy.
Well, but the dismissal will be without prejudice, you would agree, right? Because there's an issue with respect to excess.
As it happens in their case, they didn't actually provide any evidence that they so much as tendered to the excess carrier. So to say, well, we're going to keep this case alive because we've never even asked for the coverage and we've not provided any proof that we asked for the coverage, that's not a basis. So Mitchell was a little bit different insofar that there was a tender. Here, if you look at the record, they don't have a letter, and they haven't referred to it just now, of any tender to the excess carrier.
But we wouldn't reach the issue of whether there's an excess verdict. That's really for another day.
I agree. So the point is now it's just dismissed. And if they have a basis someday down the road to argue otherwise.
They can sue you, and you can say you never made a tender to the excess, and you fight it out there.
In the coverage action, but not here.
Right, in a coverage action.
Correct.
But this action where they're being fully defended and we could not possibly know that the verdict's going to exceed the policy limits, we're done, right? You can't sue yourself.
Exactly, we're done. And unless the court has further questions.
At least that's your argument. Okay.
That is our argument, and that is New York law.
Yeah, okay. All right. All right, last is AAD, Ms. DeCamp.
Yes, just briefly, Longwood's counsel had raised the issue stating that no party has appealed the lower court's grant of the dismissal of any claims of negligence against it, but we do raise in our brief that the lower court incorrectly found that Longwood Development Fund was free of negligence based on all the arguments set forth in our papers. And finally, with respect to Clark and Wilkins, comment that the work of it was inspected, and in their papers, they cite to 4 different inspections that were done. The inspections, or what they claim to have been inspections, as Mr. Klein had pointed out, one was Philip Abitable, who claims he just looked at it with binoculars from the ground. He never actually moved the fire escape ladder. They cite to my client, AAD's owner, Mr. Amaxis. However, Mr. Amaxis at page 1318 says he never examined the drop ladder, and that he was never, the only thing he had testified to is that he was never made aware of any issues with the drop ladder, but he testified that he had never examined it. Malkara project manager, Mark Pavlicek, he testified that on page 1412 of the record that he has no recollection of ever pulling down any of the drop ladders and checking them after CW's work. And finally, AIM President Virginia Stein, he had testified at 1825 to 1826 of the record that although he had used a drop ladder sometime after, he has no recollection of whether or not it was a drop ladder that was used by the plaintiff on the date of the accident. So other than that, unless your honors have any questions, I rest.
Any questions? All right. Thank you all. This was a challenging set of appeals. This session of the Appellate Division has now concluded. Thank you.
Yeah, good night.